Yeah, my lord, my lord's kind leave to mention a matter. My lord, I'm mentioning this matter for seeking leave for drawing up and completion of the order dated 19 December 2024. My lord, a copy of the order is there, and this is the letter.
You are for?
My lord, I am for the petitioner, my lord. Rajesh Sardarmal Jain. Much.
Any mentioning? Non-commercial. Actual motion item number 1 to 4.
Okay, 42. You will make your submissions with regard to 43.
But 43, 44, 45. If they want to finish their submission, let them all finish. I'll make my submission. After.
Okay. Mr. Haldar, since you were arguing yesterday, so you start with 44, your application. Huh? এটা কি আছে? এগুলো বললে হবে তো?
তোমার বলো না বাবা। Lordship knows that Dokineswar temple is a Hindu famous temple. Which has been founded by Rani Rasmani in 1855. So now, my lord, 1961 executed a deed of endowment. 1861. My lord, the entire estate of Rani Rasmani dedicated in favor of the particular deity, Ma Bhavataru. So now, after death of Rani founder, that is Rani Rasmani, now the 8th, his grandson, her grandson, my lord, executed, my lord, nominated as a Sebai. One of the Sebai came before this honorable for framing a scheme. This is the one of the, that is the Balaram Das, 1872. Now, 1929, a scheme has been framed by this honorable. The scheme is very vital. What is the aims and object of that scheme? Scheme is this, my lord, is kindly, if your lordship kindly come to page in my, the page 13. Page 13. So, my lord, I will not read the entire facts, but the relevant portion is this, my lords. Kindly come to page 16, paragraph 8. May I read? The trustees shall meet at least once a month for the dispatch of the business and other purposes for which the secretary will issue the notice to the trustee at least 3 clear days before the date of meeting, and will specify the nature of the business of the trusted at every meeting. Well, this my submission before your lordship as on day. There are 600 the Sebai.
600.
600. I have the, because of the voter list has been published by the last election, it appears from the about 600 Sebai. Now, this now my lord, very vital, my lord, this kindly come to page 70.
Yes.
Now the 17 para 10. A. This the proper management of the asset and the donation which has been accepted from the different devotees, large number of devotees, that has to be properly maintained by the management. So now is kindly A. Keep proper accounts. I being one of the Sebai, I have the right to know what is the present asset and present accounts of that said temple. My allegation is this, my lords: misappropriation of the huge fund, second, the asset which has been left by the founder, that has not been properly maintained. Third point is this, my lords: being as one of the Sebai, I have not been allowed to inspect the records regarding.
I want to take a friendly objection. This is 44. 44 is by Mr. Bikram. He's not a Shivite.
So what is the last point you were submitting?
The last point,
Inspection.
I have not been allowed. And my lord, the other point I will not argue at this stage, my lords. So now there are so now initial scheme in 1929, then subsequent that scheme has been modified in 1978. Well, the 72. Well, we say kindly come to page 21. In the 20.
Page 21.
Well, the Honorable Division Bench has been modified that scheme. So, my lord, I will not travel to your lordship to read the entire. Because of that, there are my lord, this misappropriation of funds, irregularity, my lord, of the management. The sum of the Sebai came before this honorable court. My lord, the matter reached to the appeal court. Appeal court modified certain guidelines, has been, my lord, the frame. Modifying the earlier, my lord, that is the, my lord, if your lordship kindly go to the, then, my lord, I have to take the time because of that entire order I have to read. So I will not travel with your lordships. Now, my lord, this now 1986. Now the question of 1986 has come for voting power. Three, my lord, there is the, my lord, the three branch of the family: Das, Chaudhary, and Bishas. So now the voting, so far the management has been shifted to the, my lord, these particular families, three branches families. So now my basic, my fundamental issue before your lordship is this: if the Dakshineshwar temple is whether it is the public or private, fundamental issue. The second issue, my lords, is the last judgment delivered by your lordships, considering the all other, my lord, the previous judgments. It appears from your lordship's judgment that the Dakshineshwar temple has been controlled by this honorable High Court. Only the management has been shifted to a particular, my lord, the families, but the three families, by way of election. Now, as on today, my lord, I am not concerned about the election process. Because of that, every the proceeding at my instance, I failed before this honorable court. Regarding this the election, admitted, the previous election which has been conducted by the chairman, whatever may be the appointed by this honorable courts, as on day, I have no allegation. After delivering your lordship's judgment, my submission before your lordships that there are a allegation has been made from the Sebaid as well as the large number of devotees regarding mismanagement, misappropriation of the huge fund accepted from various corners, either from the large number of devotees as well as the government exchequer.
As well as?
The government public exchequer.
Oh.
I allege. So now the fundamental issue is this: if the Dakshineshwar temple is controlled by this Honorable High Court, only shifting the management, particular family, 3 branches of the family. So that the scheme has been framed in 1986. But in course of time, for proper management of the said public temple cannot be vested for a particular families or a branch of family. Management should be, should be shifted by framing a new scheme. Because of that, it is the old scheme in 1940, 40 years back.
86.
86. Today, as under 25 million, about the 40 years back. So now, this the application of 42 has come only for for the election, for getting the benefit, for management of the 3 years. So for the one month election to be conducted by my way of appointing a special officer, the power of the special officer only for 1 month. After completion of the election process, the management to be shifted to the particular families. So now after 1 month, last the 2 years, 11 months, a huge the misappropriation fund with regard to the fund of the management has been misappropriated by the particular persons who has affirmed the affidavit 42. That is our allegations. So for the previous allegation, I have no allegation. Entire character, nature and character of the temple premises has been changed because of the guest house, which has been constructed without consulting, without any meeting of the majority member of the Sebaid. Because of the Sebaid only, by way of this election, only to participate in the election. Only election for 1 month. Whatever date has been made. Now 2 years, 11 months, they have no right to access or to see the document, whatever the as on day, what is the whether the how many months, how the funds which has been accepted or the donation accepted, they have no knowledge. Because of that, we have the right. Because of the 600 Sebaid is there. Person who has come, only 1 person. Before coming before your lordships, must be a meeting, has to be held.
1 person means?
That is the Kusal Chaudhary. He is the secretary, since the secretary holding the post.
And also objection has been raised by 1.
Objection, so many objections raised by the petitioner, my clients, other Sebaid is standing here, and also at least.
Right of inspection. Yes, next.
In this aspect, my lords, now my allegations. Kindly come to the application, paragraph 8, page 4.
Yes.
May I read? It is submitted that since 1986 till January 2025, one after another order passed by this honorable court concerning only the trustee board election. Well, I have concerning with regard to trustee board election. None of the vital issues have been decided by this honorable High Court, and there is no bar to decide the following issues conclusively when there are a series of allegations against a particular member of the trustee board from very beginning, from him assuming the charge. For that it is said that the receiver is to be again appointed in respect of the administration of the estate. Accordingly, before passing any order so far the holding forthcoming trustee board election for 2025 to 2028, the following issues need to be decided. What is the issue before your lordship? The entire state of the Dakshineshwar state is being administered by the Calcutta High Court. Honorable High Court at Calcutta had been framed a scheme for the proper management of the state, which has been modified from time to time by the Honorable High Court. But since 1986, after taking over the charge of the trustee board by the present secretary, quantum of paid and utilization of all movable, immovable properties of the estate is known specially. First. Second, there is no specificness and or clarity about the collection of management uses donation received from the various corners, including monetary sums from the government and devotee in connection with the Dakshineshwar Temple, Devattar estate. So now, this is a very vital point because of the mismanagement. C. There are a series of allegations against the trustee since 1986 alleging running a profitable establishment such as guest house, NGO, car parking, Oti Porishod, trust, Dala, etc. within the temple premises by keeping all other sevais in dark regarding the same. Now all the decision has been taken since 1986, my lords. 86, my lords, by a particular 3% by keeping dark in other 600 sevai.
Since 1986 till 2025, any application was filed alleging of any misappropriation of funds?
Yes,
In-
they are in that first
Any
time
application was filed before the court?
2022.
22. From 86 to 22, no allegation.
So far my part is concerned, there is no allegation. There may be it appears from the various order.
No. I am asking
So far
you
my
that
part is.
whether any of the Sebayats came up before the court that
Yes,
since
I
86
think
there was mismanagement of funds, misappropriation of funds, the management was not properly done. Any sort of allegations through an application before the court?
So no, this has been come in 2022.
Okay. Yes, next.
So now, there is the change of nature and character of the premises, the temple compound. A profitable business has been started by the secretary. That cannot be without the taking decision. Now, as on the date, assuming that no allegation has been made regarding changing the nature and the character of the temple compound, my lords, there is no allegation as yet. When the High Court is under control of the temple, that has been delivered by the Dakshineshwar Temple has been controlled and administered by this Honorable High Court. That has been laid down by your Lordship judgment. Then, my lord, is why a 3% keeping away the others, the rest of the 600, the Sebai. They have taken a decision for the construction of guest house or any other profitable business within the compound, my lords.
Yes.
Now, I further, my lords, requested, my lord, the present secretary of the trustee board to supply being a Sebai, supply the certain document and to allow to inspect the certain documents. By way of further making an application in 27th of January 2025. That has been stated in Annexure P2. Your Lordship got using the page 53. To the secretary, the board of the trustee, Doar Temple, Doar Kali Temple. I, Bikramji, son of late, the prayer for disclosing the following information in respect of the several property dedicated by Rani Rajmoni to the deities mentioned in the deed of Arpan Nama. I, Bikramji Das, son of late Sergeant Sajman, being one of the Sebais of the trustee board, and for proper management and disclosure of the present status of movable and immovable property asset of the Dakshineshwar estate.
Yes, continue.
Now, needless to mention herein that the entirety of the said estate left by Rani Rajmoni Das is currently under the supervision of the Honorable High Court at Calcutta. The Honorable High Court has been supervising the administration of the trust estate, Dakshineshwar Kalibari and Devotor estate. For that, it is imperative for me, being one of the Sebai, to know whereabouts and what status of the all movable and immovable property included in the deed of Arpan Nama. So now, the deed of Arpan Nama is the very vital one of the documents which has been preserved by probably by this Honorable Court. Now, I have also come to know that the entire estate of Dakshineshwar administrated by Controller at Calcutta and frame scheme for proper management of the said estate, which has been modified from time to time by this Honorable High Court. But since 1986, after taking over the charge of the trustee board by you, address the present secretary, I being one of the Sebai is in dark with regard to movable and immovable properties of the estate left by Rani Rajmoni. Lots of allegations have been surfaced regarding all the aforesaid recently, and being one of the Sebai, am apprehending the scope of the same for true. Hence, I pray the following documents. Details regarding all movable property and immovable property left by Rani Rajmoni. So I assuming this the prayer which has been made by the petitioner, applicant before your Lordship. So let them to produce all the documents before this Honorable High Court. Now, detail regarding the immovable property subject to the deed of abnormal, Details account regarding all the monetary sum received from the estate along with the management, maintenance and expenditure thereof, the specific breakups thereof from the date of assuming your charge. Details account regarding the monetary sum including the donation. This is aid is very vital.
Which one?
8, but D, page 53 is the very vital. Because of that, your Lordship knows that donation. Profitable business, what I am before your Lordship, the profitable business means there are other allegation is this. In the name of the temple, a further 4 NGO charitable trust has been opened by a particular persons and collecting the donation instead of the donation box of the Kali Temple, separate donation box has been opened and collecting the donation from there. By way of framing executing a new trust within the trust, I have the documents I can produce before your Lordship. A trust which has been further created within the state, the premises compartment, in 2000. If your Lordship, then I will address the Can the application of 42, I have already filed the affirmation affidavit in opposition disclosing the subsequent the document which has been collected from the other the Sebai regarding the profitable business at the instance of that particular persons.
Yes.
Now this the last the submission with regard to the management of the temple. Whether the scheme which was the frame in 1986 needs to be the change or not. Because of that, considering
What is the change created by you?
my change is this, my lord's
Committee.
constitutional committee.
Achha.
This
Who is the
previous
applicant in the
reduced-
particular application before writ petition? Who is the applicant?
I am not, because some devotee has filed.
You are the applicant.
Comment.
43 টা দিন তো।
This the prayer in prayer is very vital. That's it.
Okay.
Now, my lord, kindly come to my prayer. What I prayed before your lords.
Yes.
Prayer C. Now, prayer C, to direct the board of trustees to place all the documents like Jamindar record, movable and immovable property, books of account led by Rani Rajmoni record in respect of day-to-day receiving donation from the public and other record as sought for in paragraph 10. The paragraph 10 I just now I have placed before your lordship. To appoint a receiver for taking over the charge of the Doar Kali Temple and Devoted Estate till the disposal of this application. So far the pair E is concerned. To keep in abeyance of forthcoming the election of Doar Kali Temple and Devoted Estate Board for 2025-2028 till the disposal of this application. Now pair F is the very vital. Because of the course of time, a scheme at that relevant point of time, my lord, is no mobile, nothing, my lord, the CCTV footage, which has been, my lord, in forthcoming, my lord, 2025, frame a new scheme. Because that scheme has to be framed because of the change of circumstances. Change of circumstances because of that at prevailing previously in 1986, it may not be accepted any donation from the devotee. Now, as on the day, a large number of devotees donated for the purpose of development of management temples or any other purpose. Government, state government, central government has donated huge money in favor of the temple. So now famous key or G, constitute a constitutional committee for taking over the charge of management.
Okay.
Now, in this respect, my lord, if your lordship allow to, my lord, place certain judgment of the Honorable Supreme Court as well as the Honorable High Court. So, my lord, I am relying on judgment. There are, my lord, the Supreme judgment, but the issue before your lordships regarding, my lord, is the mismanagement not proper accounts has been maintained by the present management. And when a allegation has been made, a proper inquiry is required. And due to change of circumstances, a new scheme has to be framed by way of Malada appointing either in receiver or from a committee.
Yes. Yes.
Now, my lord, I am relying on judgments in 2006, volume 7, SCC 490. Just
409.
490. 2006 7 SCC 490. Paragraph 10. Maladi. 9 and 10 is very vital. Maladi, the issue.
Just a minute, just a minute. Very good.
The issue before the Honorable Supreme Court that whether a temple has become a public or private. The second, my lord, is the guidelines as well as the order which has been passed by the Honorable Supreme Court, considering the present situation. So now, paragraph 10 in that judgment, in order to ascertain whether a trust is a private, following factors are relevant. If the beneficiary are ascertained individual. So now, my submission before your lordship, deed of endowment in favor of deity, Ma Bhavataram, executed by the founder. Now, second, if the grantor has been made in favor of individual and not in favor of a deity, the temple is situated within the campus of residence of the donor. It is not within the residence of the donor campus. Second, my lord, this is the paragraph, the 4th point. If the revenue records of the entry suggest the land being in possession of the individual and not in the deity, on the other hand, an inference can be drawn that the temple, along with the property attached to, it's a public trust. When it is become a public trust, if the public visit the temple as of right. So now, as on the date, public visit has been allowed, a large number of devotees has been allowed to visit the temple. If the endowment is in the name of deity, and the second beneficiary are public. So now this is my submission before your lordship. Management, the beneficiary. Who are the beneficiary? Beneficiary may not be a particular the Sebai. The founder gifted that property in favor of particular deity. Only the Sebai that been appointed by the founder for management. not profitable business or whatever, if the donation collected, no, my lord, the account has been properly maintained. Second, my lord, this is the one of the judgment. Second, my lords, I will not, my lord, the place, other, my lord, there's so many judgment is there, but I will not place. This is the latest judgment of our Calcutta High Court, reported in 2013, volume 5.
Volume 5.
2013, volume 5, CAJ 583. The same issue in respect of our famous, another famous temple, Kali Ghat. আপনার নামে এটা ছিল না, দেখতে হবে। This is a paragraph 127, the issue before the Honorable Division Bench. Issue, a writ petition. This is the PIL matter. Regarding this people lordship, no proper when a complaint has been lodged regarding mismanagement, misappropriation of huge fund, either the existing estate led by Rani Rajmoni or donation collected from the large number of devotees as well as the public exchequer. So no allegation has been made against a particular person. No inquiry has been conducted as on that day, my lord. When herein, my lords, lots of allegations have been made against the mismanagement, changing the nature and character of the temple compound, and the asset, movable property which has been left by, that has been one after another sold out with by the keeping in dark of the other 600 Sevites. Now in the now 127 and kindly come to 3. I can read the paragraph 3 of that judgment. According to the scheme, committee of management has been constituted. The same includes the district judge and other officer also. The treasurer of the temple committee has to keep the accounts of the asset and liabilities of the devotor estate. All kinds of offering to the deity, including those in the shape of money, ornament, jewelry, fish, gold, offering of food, stuff, offering cloths, all other ornaments, temple area belonging to the devotor estate and shall be remain in charge of the treasurer. Now, paragraph 6. It is also submitted several illegally occupants of the temple has been, the illegal occupant, I can say, repeat that. Because of that, a profitable business has been started because of by constructing a guest house, Dala house, by taking the money from the hawkers. They have been allotted, but the fund taken from the settlement that has not been maintained properly by a particular person.
And taken from
the person who has been allotted a particular the portion of the constructed portion within the temple compound. That has not been properly maintained. Because of that, only 3%, elected 3%, taken all the decision. Now, this is the paragraph 7. No proper inquiry has been conducted over various allegations made from time to time. PR has also been made to direct the investigation of the affairs of the temple by independent body like CBI. So that is the prayer also before the appeal bench. It appears from the appeal matter. Prayer is the same. To investigate by an independent agency regarding mismanagement of the funds and donation account, whatever it may be, that pair can be the submission can be made by the my learned friends. Now, my lord, kindly come to again the guidelines which has been the considering the all aspects. This Honorable High Court Division Bench paragraph this the 38. The 34, there for inspection of the relevant documents during the pendency of that the application, there was a direction for inspection of the certain irregularity in presence of the 6 Sebai and 6 representatives from the public. Yes. Paragraph 34. May I read my lord? There are 11 members of the Kaligarh Temple Committee. 5 are Sebais and 6 are non-Sebais. Committee has been made following the suggestion for opening the donation boxes. Out of 6 non-Sebais, 2 non-Sebais and 1 Sebais member shall be chosen by the President Kaligarh Temple Committee for the unsealing the collection boxes and keep account of the same. The collection boxes to be unsealed and accounted by them in the presence of the days Sebais. The computerized accounts of the daily offering as suggested in paragraph 13 of the resolution of the committee requires clarification. With respect to the account of the acting secretary of the Kaligarh Temple Committee has given the suggestion that sealed tonami boxes to be fixed in a possible corner of all temples such as Garbhagriha, Joy Bungalow, and Silver. Now, my lord, this kindly come to 38. 38. Now, this is the 38. The 38, my lords, considering the aforesaid suggestion or the allegation, counter allegation may be come from the other side. A district judge has been appointed. Well, we feel that the necessary issues are following direction. Computerized the daily account system is required to be introduced forthwith. Apart from that, there is the necessity for collection of the offering into the sealed pranami boxes and also the cash in the sealed boxes. They are required to be provided in the Garbhagriha, such and other places where the offering in kind of the cash is made. So it is also considered necessary that the CCTV footage of the opening of the sealed boxes offering, including of the accounting of the ornaments and other articles is made, and directly computerized entry is the made along with the weight of the articles. For that, late committee provided proper weighting matching on which the such ornament can be weighed. The weight, ornament, and the other article which are offered should also be mentioned in the computerized account every day. So now this is then considering the same. Now kindly come to so far the development project. Some committee has been formed, that is the para 39. Then say committee has been framed because of nobody, no one can be the vested interest, keep their management, entire management under their control. Because of that, there are 600 Sebai. Only the 3% or 1% will come and say the management should be under the control of the particular the family when the donation has been accepted from the various corner, like this the large number of devotee as well as the from the public sticker. So now a committee has been formed for proper management. Now paragraph 42, proper system of puja.
Yes.
Now, again, my lord, I am coming before your lordship with regard to who are the aggrieved persons. I am relying on judgment, another judgment, 2022, SCC online Supreme Court cases. Sandapant. 2022 SCC online, my lord, is Supreme Court 1023, paragraph 38.
দেখি দিন ওরা
SCC online SC 1023.
give the copy of the judgment.
Paragraph 38. My lord, there can be no doubt that the state has the right to control the non-religious affairs of the temple situated on government land and ensure that donations received from the public are not misappropriated or wasted. If the fund received from that is now another judgment, my lords. This is the last. I can think the last judgment. Last judgment. Government land. ব্যক্তিগত না তো the 1970 এটাই তো এখন প্রশ্ন in course of time this the 1972 SCC sorry my lord, it should be my lord 1969 1969 to SCC 853 paragraph 15 1.5.
Copy to them.
So now herein my decision is that may I read her? Though my lord, this the sorry my lord, this is the one
Copy. Okay, read.
Though most of the present day Hindu public temple have been found as a public temples, there are instances of the private temple becoming a public temple in course of time. Some of the private temple have been acquired great deal of religious reputation, either because of the eminence of its founder or because of the other circumstances. They have attracted a large number of the devotees. In course of the time, they have become a public temple. Public temples are generally built or raised by a public, and the deity installed to enable the members of the public or a section thereof too for offering worship. In such a case, the temple would clarify be a public temple if a temple is proved to have organized as a public temple. Nothing more is necessary to be provided to show that it is a public temple. But if the temple is proved to have originated as a private public temple, or its origin is unknown or lost in antiquity, then there must be a proof to show that it is being used as a public temple. In such a cases, a true character of the particular temple is decided on the basis of the various circumstances. In those cases, the courts have to address themselves to various questions such as, if the temple built in a imposing a manner that it may be prima facie appear to be a public temple, are the members of the public entitled to worship in that temple as of right? If I have the right to worship of that particular temple, it is a matter of right. So now I have been second submission before second query of this of the Honorable Supreme Court, whether the Sevas and Utsava conducted in a temple are those usually conducted in public temples. So now, my lord, in the Kali Puja and in the 1st of January, there are Seva Utsav is going on, huge donation. Even, my lord, if I will go there, I have to pay some donation in the donation box. Now, third one, they have a management as well as devotee have been treating the temple as a public temple. So now this is the
Give the copy.
I can hand over my copy. There is the only, my lord, I have given the private authority.
Para 15.
That's-
Hmm.
So now, my lord, this Suman.
That is all.
Judgment.
45. 45 application.
My lord, what Mr. Haldar has submitted before your lordship, he has covered most of my submissions, my lord. But I will still agitate my lords on one point, that my lord, whether the suit temple, the Dakshineshwar Kali Temple, with the passage of time has become a public temple or not. Because if my lord holds that this is not a public temple, I don't have any case before your lordship. And if it is a public temple, then my lord, whether the scheme framed in 1986 is appropriate in this particular time. Why I am saying so, my lord? Because non-religious functions of a public temple, my lord, comes under the realm of
You have a
executive
copy
control.
of that writ petition?
Writ petition, my lord, I don't have right now, my lord. But my lord, I have the prayers, the grounds, everything is contained in my application 45. My lord, non-religious functions, or my lord, the secular functions of a public temple comes under the realm of the executive control of government.
Your lordship, so did I have a copy of the which one reference is that? I don't think it's my copy. Your lordship.
Get a photocopy of that and give it to.
If you lordship wants to see my lordship, I'll take it at the end of the day. Photocopy. That's it.
My lord, why I am saying so that this executive control of the state is necessary? Because what, my lord, currently happens due to the 1986 schemes, due to the misuse of the 1986 schemes, that a particular set of Sevites is completely usurping the offices of the Board of Trustees for the last 20 years, and their personal wealth have been increased in astronomical fashion, my lord. So, my lord, essentially a public temple is being managed by individuals who have no accountability to the public. Although the funds have been accepted by the public exchequer due to several schemes framed on both by the state government as well as the central government, and huge amount of donations being collected from the devotees who come to the temple, thousands in numbers daily. Now, my lord, this same issue, since this is my application, my lord, the same issue is pending before the PIL bench as well, my lord. And what my prayer before the PIL bench as well, that my lord, if election for 2025 to 28 is permitted under the present scheme, the estate properties of the temple will deteriorate and diminish even further, because
Prayer
the
number?
the very serious
Which
allegation-
prayer?
It is, my lord, the grounds taken that no. This is, my lord, paragraph 5, page 3 of my application.
No, in that writ petition, where is the prayer that regarding election?
Regarding election, my lord, I am coming back. B- yes, my lord. Kindly comes to page 10. I, the prayer I. An interim order or orders thereby appointing the district judge of North Chobbish Parganas or ex-justice of this Honorable High Court, Calcutta, or any independent agency or any other person or persons for taking over the charge of the management of the said public temple when there is involving huge public money and sentiment of public at large or devotees for their worships are involved at the said Dakshineshwar Kali Temple in West Bengal forthwith.
Yes.
Mr. Haldar has already placed before your lordship the prayer E, a writ or writs in the nature of mandamus commanding the respondent, agent, successor in office, representative, and each of them to pass an order superseding any outcome of formation of any committee in CS number 308 of 1872 pending before this Honorable High Court concerning the Dakshineshwar Kali Temple and trust related thereto. So, my lord, since the PIL is pending, so, my lord, I have only one prayer before your lordship. My lord, at this present scheme, this scheme that is running since 1986, in my humble submission, my lord, this is not sufficient in this present day. And either my lord can frame a scheme or let the Honorable PIL bench frame a new scheme, my lord. This is my only prayer. Because money from the public is being taken and no accountability before the public. No accountability to the public, my lord. Why, my lord, I'm saying so? Because to maintain, my lord, judicial discipline, if the PIL bench, my lord, decides the issues, then it would be better, my lord. And the same issue, if adjudicated by your lordship, my lord, it will again the same issue will be, my lord, agitated before the PIL bench, and it will be, my lord, wastage of precious judicial time. These are my submissions, my lord. Apart from this, Mr. Haldar has very well put his case.
Yes. That's all.
That's all, my lord. And apart from this, my lord, I am not a devotee, my lord, and I have to disclose. Sorry, my lord, I am a devotee, but I am not a Shebai. So, my lord, in that regard, may I place, my lord, one judgment of this Honorable Supreme Court. The citation is 1976, Volume 1 SCC, page 671. I have a copy of that judgment, my lord. The citation.
Citation, what is the proposal in place? How would I deal with the judge? Hey, this is not the way you argue, madam.
But my lord, I am just trying to satisfy the locus standi before this honorable court. My locus standi before this
So
honorable.
which paragraph you are referring to and what
Yes,
is
my
the
lord. The paragraph is paragraph 12.
paragraph 12?
Paragraph 12.
Read.
Although this pertains to, my lord, certiorari jurisdiction, but may I just read out, my lord? This takes us to the further question: who is an aggrieved person? My lord, I am an aggrieved person. I go to the temple, I offer my offerings, I donate the donations. Before whichever box Mr. Haldar has indicated, there are several donation boxes. Who is taking that money to where? To whose pocket it's gone into? I don't know. And What are the qualifications requisite for such a status? The expression aggrieved person denotes an elastic and to an extent an elusive concept. It cannot be confined within the bounds of a rigid, exact, and comprehensive definition. At best, its features can be described a broad tentative manner. Its scope and meaning depends on diverse variable factors such as the content and intent of the statute of which contravention is alleged, the specific circumstances of this case, the nature and extent of the petitioner's interest, and the nature of the extent of the prejudice or inquiry suffered by him. English courts have sometimes put a restricted and sometimes a wide construction on the expression aggrieved person. Thereafter, my lord, the same judgment, paragraph 34. The expression ordinarily indicates that this is not a cast iron rule. It is flexible enough to take in those cases where the applicant has been prejudicially affected by an act or omission of an authority, even though he has no proprietary or even fiduciary interest in the subject matter. That apart, in exceptional cases, even a stranger or a person who was not a party to the proceedings before the authority but has a substantial and genuine interest in the subject matter of the proceedings will be covered by this rule. The principle enunciated in the English cases noticed above are not inconsistent with it. My lord, this is regarding my locus standi.
Yes.
And my lord, there are several representations before ED as well as the Secretary of the States, Secretary of several departments of the states, my lord. From paragraph 20 onwards, may I just read out from page 20 onwards, my lord, of my application. The relevant portion is, my lord, at page 22. May I just read out, my lord? It is pertinent to mention that for the interest of public at large, specifically for the Hindu community people, I am ventilating the following objection of the mismanagement of the said temple. The movable and immovable property left by Rani Rashmoni in the name of the said Devottar estate with a pious religious purpose have been misappropriated or destroyed or damaged by some vested interest persons, specifically by some of the alleged Sevites. It is reported that one after another movable and immovable properties left by Rani Rashmoni in the name of the said temple, sold out by some of the alleged Sevites for their own personal gain or interest. As a result, no religious or any manner of whatsoever is being served for selling of the said Devottar property. After demise of the said original Sevites who have been presently representing the said Devottar property is not known to anybody but public at large. Specifically, Hindu community is in dark with regard to present assets of the said temple. No proper financial accounts of the said temple which have been maintained by the present authority of the said temple, which I pressed earlier, my lord, that no accountability at all. Present temple authority is not maintaining proper accounts, particular day-to-day donation offered by the different pious men, including different governments like central and state government. The aims and objects of Rani Rashmoni is totally frustrated due to personal interest of some vested persons who are in the name of God increasing their own financial wealth day by day. It has come to know that proper administration is not done, which is properly leaded. The Devottar property shall be destroyed or ruined if the proper inquiry is conducted against the present management who are in charge more or less 20 years in respect of their assets and
Okay.
property, everything will be revealed, my lord.
Any other submission?
The other submissions, my lord, is at the instance of the current secretary of the Board of Trustees, my lord. There are 4 NGOs that are currently being run on the temple premises. There are several other gainful businesses that is being run by him. Some land records are being, the title of land records are being recorded under his name. That is our allegation in the PIL as well, my lord. So, my lord, I conclude my submission with this.
43 already heard.
Hard.
No.
It's not hard because my senior is here. So it's rather only started when it has to be concluded by. With some points.
My lord, the judgment I relied upon, may I just hand over a copy of that judgment, my lord?
Naamটা দিয়ে দিলাম। He has already started, but my lord, it is to be concluded.
43
Yes,
heard.
43, your lordship has heard, no doubt, but it has not been completed because that it is to be completed in the sense that means that it is such a vital question which we are going to be raised that has not yet been kind of raised.
43 heard.
Your lordship will kindly.
Your friend made submissions.
Yes, my junior
After
has
that,
made-
Mr. Amitesh Banerjee started yesterday, but since 44 and 45 was not listed, I placed it.
No, but your lordship
Please
possibly-
don't insist.
No, your
This is
lordship
not the way,
possibly-
Mr. Adhikari.
possibly remember that my
Ask him
junior-
whether he has
Yes,
concluded. or
my
not.
junior has already started.
Not
And my
started. He has concluded. Mr. Amitesh Banerjee started to reply.
Because he has not concluded because of my lord, in absence of the junior,
This is-
senior, in absence of, when the senior is on the
Give
leg and the junior starts, then my lord, that the role of the senior is either to remain outside or means to continue it in this way. But my lord, that in the fashion, my lord,
No, you were not present in court.
remember-
Yesterday, you were not present.
No, yesterday I was not present. That is the entire trouble because I was on my leg. And when he started, that
He
means that
didn't. He didn't submit.
no, he did not conclude it because your lordship kindly.
Please.
Kindly see,
He
your
did
lordship-
not. Your
What is your name? Lord possibly remember that means the entire episode. Your lordship possibly remember
43.
43. Your lordship has given me
Wait,
chance.
wait.
That means,
Wait.
yes, Mr. Odhikari.
Wait.
Given chance. And after all, you.
He had made his submissions yesterday.
No, he has made commission, but my lord, he has not completed.
After he completes, Mr. Amitesh
No,
Banerjee
my lord.
started his
Yeah,
submissions in
my lord,
43.
the situation here is, my lord, what I find.
If
My
43
lord,
was
which is not expected and desirable. My lord, Amitesh is also junior to me. At my age of 72 years, after covering 45 years of practice, it is his personal case as if he stands. And my lord, that it is very difficult.
now
for
you
our
are going
juniors.
outside the application.
No, my lord. It's very difficult for the juniors to tackle the situation. Only, my lord, that because I am to conduct at least the 9 or 8 cases before the 8 or 9 courts. And my lord, it is very difficult at least to come at this age of 72 years. My lord, that what I am to say, my lord, that he has placed one thing. And my lord, that then and then, my lord, that he has my lord, come into the picture. And your lordship possibly remember, since the very beginning, my lord, I raised the question before your lordship. And that question has not yet been answered. And your lordship has given me chance that, well, Mr. Odhikari, you will be given chance ultimately. Now, when the matter is going to be for a complete episode, complete end of the episode, then, my lord, I am making
It
my
is not-
fine.
Wait. You have stated many things. When the matter is being taken up, the advocate concerned should have taken a passover on your behalf that you are in legs in some other court.
My lord, it is because it is such a case, my lord. They are,
Or such a case.
my lord, your lordship.
If you would have
My lord,
indicated
your
to the
lordship-
court,
My lord, can you
try to understand.
First of all,
Try to
your
understand.
lordship- my lord,
It is wastage of time of the court
no,
that a
it is-
person
my lord, it is
he
the more
starts
wastage
arguing the
of
matter.
the time of the court when we seniors,
We-
we are seeing that the ridiculous adventure is going on here. Ridiculous adventure.
that may appear to be a
My lord,
ridiculous
why it
approach
is
to
such?
you.
We are
I
trying,
don't feel so.
my lord, we are trying here to.
It would have been
my lord,
convenient.
to
It would have
me,
been convenient if it had been indicated to the court
my lord,
that
it
you
is
will
our
argue the
duty.
matter.
It is our duty to enlighten the court. That means that how
It's not the
how
question of
ridiculous
enlightenment.
activities are going on. Is it not the duty?
How long he has argued? Just ask him.
No, I am not saying
Yesterday I
so.
have given him time.
I am not saying so. Is it not necessary?
After he concludes, you
My-
come up
my
and
lord,
say that
is
you will
it-
also argue.
Is it a technical question to be raised here in this case that where so many cases?
I'm not saying that. I'm not saying that.
First of all, your lordship.
I didn't see. I didn't say that I will not hear you.
That,
did I say
is
so?
the moot question. That is the moot question.
Had it been indicated, see,
anyone can
you are-
get out. My lord Supreme Court has made it clear through the.
had it been indicated,
result of
ask him.
judgment. Yeah.
Please, sir.
Yeah.
Had it been indicated,
Because-
I will allow you. This is not the case.
I am grateful. I am grateful.
I will allow you. Go for 1 hour. No problem. But
That
this
is
should
not-
have been indicated by him yesterday that you will argue the matter. Now you come up and say that you will argue
Because
43.
I was busy in some other.
You should
court
have
in such a
indicated.
way.
Is it correct?
My lord,
Then
my lord, that the actual.
why Mr. Odhikari is saying so?
No, my lord, Mr. Odhikari is saying so.
What
at
is
that point
what
of
is
time.
going on? 44, 45 not listed. Notice of motion not given. I am giving you liberty to file it. Ask your
Yes,
45.
that-
Ask them to serve copy upon them.
they-
Then also you come up and see you are not getting opportunity.
my lord, your lordship.
How
will kindly
funny.
see. My lord,
Everything is appear
my lord,
ridiculous to
must
you.
remember that every time I have come,
No, no.
maybe it's very.
What is the
My
use of
lord.
submitting like this that
No,
ridiculous
my
things
lord,
are
let me
appearing?
check, my lord. How ridiculously they are proceeding, my lord. It is necessary in the
We are
interest
wasting
of
time. Come,
justice.
come, come.
That means that a senior one
43,
be allowed.
43. Oh,
My
okay,
lord,
okay,
kindly
okay. Make this submit.
Kindly see, I
We
am
got
just
the point.
exposing myself on thrashing on all the what episodes are there. If your lordship will kindly see, are these not ridiculous attempt on the part of it? Whether this court has got jurisdiction to entertain
Okay.
these type of such applications when a public interest litigation is pending and sub judice before the Honorable High Court. And my lord, in that very case, I myself was the whistleblower, I, Mr. Vijay Odhikari. And my lord, on the basis of it, my lord, that the Honorable Chief Justice and the companion justice was pleased to pass an order that let the Union of India and the state government will file their respective reports in this concern. That part, my lord, kindly have a look to this only. If your lordship will kindly see, my lord, that these orders, they have suppressed. What else remain? What else remain? Kindly see. Kindly see, my lord. Is it a mockery of justice where all parties participated?
Page.
My lord. My lord, at page 15 of their opposition. Page
Into
49.
43 opposition to the
Kindly have it.
In our opposition.
These are in their opposition. Therefore, I am telling you.
I discussed my opposition.
Yes. No. You- you have placed it.
it.
You have placed it. My lord, suppression is also such a suppression when it is given in writing, but it has not been submitted. Or the very particular means the intention. A senior advocate should be very cautious before the honorable court. Therefore, we do not apply for certified. We do not apply for it. And I am that person. With Indra Jai Singh, I was the person. That means that the PK Odhikari in the Supreme Court.
Please make your submissions. We are not here to certify anything.
Kindly have it here. Kindly have a look, my lord. This is there at page 16. If your lordship will kindly take note. Page 15.
15. Yes.
My lord, learned counsel for the state as also Union of India are directed to file their reports in the form of affidavits within 3 weeks. Kindly have a look. If that be the position, kindly have a look. At page 13 it starts. So many persons, so many advocates have appeared.
Yes.
Beforehand at page 8, your lordship will kindly see. Seven 11/2022, Annexure A, page 7. Your lordship will kindly see. Page 7. Now there all the parties appear. And page 8, kindly go through the order itself. Learned counsel, has your lordship got it? Learned counsel for the parties are permitted to place on record a copy of the plaint in CS number 308 of 1872. Learned counsel for the parties means the onus is cast upon them also because that they are ventilating their grievances before your lordship also. And the relevant orders passed therein to ascertain the scope of the pending suit. To ascertain the scope of the pending suit, that being the position, whether it will be a fair justice if they will poke this honorable court to get this matter will be decided here until and unless it means a clear outcome comes out from the division bench. I am asking myself, I am asking my conscience that the scope of the pending suit, the suit, whether it is pending or not, it has been projected that this is a pending suit. Therefore, the Honorable Division Bench, presided over by the then Honorable Chief Justice,
Carry on.
has got the only means rather this very, it is a very narrow, pedantic, cabin crippled scope, what I am to say. That means that whether the scope of the CS original 1872, CS 308 of 1872 has any scope to be further extended up to this period where they are praying for extending the election process, for usurping the managerial process by taking the management not by their own effort, not by their own caliber, but through the process of law, by making a shadow director, that means the court. Whether court can be a shadow director, Supreme Court has made it clear. These are called the shadow director. If the parties have intention, at least that to make the court a shadow director, and court cannot even means tolerate all these things. Court is answerable to it. The term is, which the Phalius Nariman has narrated. That means that the court is taking every responsibility of all this. Therefore, court is answerable. Now the court is making them all arrangements to infiltrate the money, to infiltrate the fund. Whether the court can ignore its own liability. Court is above all. If the court is not in a position to see the usurpation of money by the black hands, then the court cannot interfere in all these businesses. Here the court is going through, I was watching throughout the months after months, your lordship is taking up the matter. And they have the sole motto is, whenever there is an election, they come and they jot down every problem, and the court, in a usual course, like a rather secretarial activities, that well go and do it. But whether it is practically feasible or not, whether the court has got no duty at all, whether there is manifestation of justice or not, the court is not to see it. If the court is not to see it, then court is not to interfere in the matter. And then, my lord, that the scope of the case, when it is pending before the Honorable Chief Justice's bench, whether this court can intervene, I am asking my conscience at this age, at this old age, kindly take out that it is a submission of Mr. Odhikari.
Yes.
Therefore, if, my lord, not only an order is to be followed, but it must have to be followed in its true letter and spirit. This is the core concept of our judicial system. That being the legal position, when a division bench presided over by Honorable then Chief Justice Prakash Srivastava with Rajarshi Bharadwaj, then in the division bench, when the order has been passed in this way, in presence of both the parties, that means the plaintiff of CS number 308 of 1872 are permitted to place on record. Therefore, that the place on record, the copy of it, it means that means the court, the Honorable Division Bench, then decided over by Honorable Chief Justice, still is in scene of the entire matter. Because there is some story regarding CS. That being the position, my lord, I have all the judgments that whether it is usurpation of the Honorable Justice's roster or not by this Honorable Court. If your lordship will pass any order regarding the election, usurpation of the roster or not, why they are not proceeding it, and whether this order, if still subsists in the judicial decorum, whether perfectly passes or not. Therefore, my lord, with very, very humbly, I am submitting with ample force with my submission that whether this Honorable Court has got any jurisdiction to pass any order when the scope of the particular CS is pending before the Honorable High Court and before the division bench of the Honorable Chief Justice, and they have raised no objection. And is it not suppression? Is it not suppression? Therefore, I was saying, Mr. Banerjee is submitting everything. I am giving something, but I am not submitting. Means placement and submission. When it has placed, it has not submitted. If it is submitted, then whether they are not slapping on their own, means rather on their own or not, that is I am asking. My lord, then we have seen here that many words are passed. And definitely we are also in our old young ages, we have done it. But when we have crossed these ages, then we are thinking, no, we are not to take all these. My conscience compelled me to come in, that when all the parties were there, you will also kindly see the attendance of all these, the giant figures they had appeared. Means they had appeared and all the parties. Can you lordship imagine? That means Satyangshu Bosu, Ranjan Bachwa, Kishore Datto, Pranit Rai, Amitesh Banerjee, Probal Kumar Mukherjee, Rohibot Banerjee, Nadasha Rai, Anjan Bhattacharjee, Rana Mukherjee, and at Ashok Kumar Chakraborty, Lanet ASG, Deepak Kumar Tanpat, Anirban Rai, Nilotpal Chatterjee, Debraj Sahu, the government advocates in all pageants, in all persons pageants, if the matter is before the Honorable Division Bench, passing any order which may cause and which we are already means rather raising the grievances that yes, if such order will pass in a mechanical way, and then the court will have to take risk of it. And but without taking this, that well, all these orders have been passed, it is such. Since 1986, my lord, it's a common question. My lord, if the election is been allowed to be proceeded with, it's a farce or not. Kindly, your lordship, an election means there will be election, a fair election. Non-participation of an election, my lord, in the election law, your lordship is well aware. That means means the election itself is a farce. Means the necessary quorum is not there, like a quorum non judice. Therefore, if the election is such, since 1986, a committee was formed. 40 years, the same committee, they are continuing.
What is quorum? I do not understand.
My lord,
If somebody does not file nomination,
if somebody does not file the nomination, then
Quorum
what
is
is the
sufficient.
role of it? Is it not either the court will arrange for all these, or the party means rather the party through proper advertisement, or rather through different means infrastructural means rather equipments, they will continue that all the persons, they must have to be noticed, and the fair election will be there, so that there will be no agitation, there will be nothing at all, free and fair one. And whatever may be, all these questions, when it is placed before the Honorable Division Bench, and the Honorable Division Bench is taking up the matter, is already ceasing up it, then your lordship is doing order in this way, in piecemeal way, without taking responsibility, and it is running in the list. Item number 633 of the combined list. And my lord, kindly, my lord, notify it. That means that in these days, means that the situation was there because of the high price of the means rather print, etc., my lord, it has been cut short. Still, the Honorable Division Bench, my lord, while we are mentioning before Honorable Chief Justice, my lord, myself has the experience. My lord, Honorable Chief Justice T.S. Sibyanam is well, yes, Mr. Udhikari, I am taking up this matter, but you see, kindly let it be here. We are, my lord, that we are every time we are placing it. It is definitely, there cannot be, my lord, the collateral proceedings before the two courts. My lord, otherwise there will be no judicial decency, decorum. My lord, what is the sanctity and wisdom of the judiciary? My lord, it is running in the list. Even today's list, my lord, it is running as item 633 of the combined monthly list. And they have suppressed these. Well, is it not the duty on their part, at least to bring it to your lordship's notice? Or rather that well, it is expected from a senior advocate that it is such. That means that the matter is pending before Honorable Chief Justice Bench 633. And there are avalanche of cases by which the courts are painfully, my lord, seeing, but they can't do. Honorable Chief Justice has got the same problem. They know us physically. That means, yes, Mr. Udik, I understand that the matter. My lord, the situation is such. My lord, they know very, very well. That means that every time they get notice of it, they are ready there. At least Rohibot is there every time. But my lord, that when it is there specifically, that means that at page 8, what I have said, learned counsel for the parties are permitted to place on record copy of the plaintiff in CS number 388 and the relevant orders passed there to ascertain the scope of the pending suit. To ascertain. Therefore, if that to ascertain the scope of the pending suit, if it is to be yet to be ascertained by a division bench and passing any order in between by the honorable court, by which they will get some means rather unusual benefit, which we are always thinking of, then whether it will be fair disposal of a case, that I am asking to myself. Then my conscience has compelled me to push that very particular question in the mind of this honorable means institution. That means that what is going on. That was. Now, if your lordship will kindly see, again, my lord, kindly see, if it is such, then my lord, your lordship will kindly see, that means that one after another. If that was that order 7/11/2022, where it has, my lord, it is the far back to their this application which is pending before your lordship. Why they have not filed it before the Honorable Division Bench presided over by Honorable Chief Justice? At least that let there be such, because we are in a hurry. Justice hurried means justice buried. Make haste, but not in a hurry. That is the core concept of our judicial system. Now, if your lordship will kindly see, if the scope of it is to be then list on 5th December, thereafter on 5th December, kindly your lordship kindly see, then at page 9 of their application itself, my lord.
Which application?
Of their opposition. Of their opposition, my lord. That opposition, my lord, that they have stated they relied the T. Banerjee and company, Rohibot Banerjee. And in the original application, they have not disclosed that this is the scope of the CS. Scope of the CS. Because, my lord, already Honorable Justice Devanshu Basat has come to this definite conclusion. And they withdrew it. If they did withdraw it, then whether they can come again in a fine way. Whether it's this type of arbitrariness on the part of the party, whether should be allowed to be continued, or whether it is not a dishonest attempt on the part of it, and then when they have not done with a clean hand, their petition will not only been summarily dismissed, but they should be put to jail. Put to jail. Who is this Kushal Chaudhary? A particular vagabond. He is continuing since 1986. I am residing here. My conscience compelled me to come here at least for this case, because I am the local resident there. I have my residence. I have born and brought up there. I have seen what is the situation. At the age of 72, I am here. We have also given contribution to it. The Bhattacharya family has got good contribution there. I belong to that family. Therefore, where these monies goes? My mother is still alive at the age of 99 years. But they are still, their thinking is such, and how they are selling these very particular emotions. The Lord should kindly see. So my conscience committee, if that being the position, thereafter, my lord, at page 10, then you'll come, my lord. Series of it, they have not raised any dispute. Again, my lord, that is set of lawyers they have. Again, my lord, that is so means Saptanshu Bosu, Ranjan Bachwa, Kishore Dotto, Amitesh Banerjee, Promit Rai, Prabal Kumar Mukherjee, Anirban Rai, Nilotpal Chatterjee, PL. Again, my lord, again, and page 10. Again, it is such learned counsel for the respondent number 11 has submitted that he has, means our Mr. Pankaj Haldar, his conscience compelled him at least to place it, my lord, as per your lordship's order. We have tried, but we could not get the certified copy of it. Honorable Division Bench was, my lord, painfully, my lord, watching everything. And my lord, then the order is, that means that he has already applied for the certificate of the pleadings in CS number 308 of 1872, and relevant orders passed therein, but the certified copy has not been supplied till now. My lord, kindly have a look, not only an order, but my lord, the letter and spirit of the order, how it has been, my lord, that it means molested. The order has been molested. It is the ravishness of justice on at the hand of them, and they have not given in that everything. What is the development? It is not their duty. They have brought all these advocates and giants in the institution before the honorable court, at least to have their end. The registry is directed to expedite the action on the application for grant of certified copy and supply the same as expeditiously as possible in accordance with law. Therefore, my lord, that we have done everything, we are still doing. Page 10 has also got of their opposition. Of their opposition, page 10. My lord, again, my lord, kindly see. Then what is it? Then again, now, my lord, 2012-2020. What is going on there?
Page?
Page, their page, my lord. Page 11, their pages, my lord. Same set of lawyers, so many advocates. My name appearing, Vijay Odhikari, read such and such, and etc. And also the Saptanshu Bose, Ranjan Bachwa, etc. And also means Manibana, etc. Now, in their pages at page 12, my lord, the order of the division bench presided over by same honorable Chief Justice Prakash Srivastava with Rajashri Bharadwaj J, my lord, at page 12 of the order dated 2012-2022. Their opposition, my lord. Opposition in GA 43 of 2024. Therefore, in our GA, we are daring to file all these things. If they are daring to file all these things, if my junior is not in a position to narrate everything, is it not my professional duty, my lord? 1987, volume 4, Supreme Court cases, page number 389. Ram Jetmalani was put under criticism by the then Honorable Chief Justice Ranganath Mishra that, well, Mr. Jetmalani, then at that point of time, no, it's your professional duty to expose everything before the court of law because court is blind. You have written down many things or not, but you have submitted. Therefore,
Again, you are coming to square one. I have allowed you to make your submissions whatever you like.
I'm saying, my lord, they are.
Again, you are referring to that you have been deprived by the court to not making submissions. Again, you are coming back to square one.
No, not I'm saying, but my lord, that is, well, my lord, it is his patience, my lord, that is, we are not in a position that is, we have to enlighten the honorable court. Is it not his duty? At page 12, his name is appearing there. All the giant lawyers are appearing there. In their presence, it is such. And a counsel for the respondent has certain criminal officer and the methodology of the present in public interest litigation. Now, hence they are permitted to file their affidavit in opposition, confining it to the issue of maintainability of the petition within a period for which they have evident reply. They are filed. Now, when they have filed it, is it not their duty when we are doing unilaterally before the division bench? Is it not their duty at least to cooperate with the honorable division bench? এটা ওদের নাম
Yes.
Now your lordship will kindly see. It is more interesting if your lordship will kindly see. My lord, I am asking to myself one question. My lord, where the state and union government has been made parties and they have intervened. They could have said it is a private trust, we have got no business. It is a public trust, they have some business. At the very threshold, the state government, the central government, they appear here. Until Mr. Anirban Rai and GP appeared along with Mr. Eden, Mr. Kishore, and also Mr. My lord, the ASG Ashok Chakraborty. My lord, in presence of all of them, at page 15, my lord, in presence of all of them, and they have accepted it. They have accepted it. Yes, there is some malfunction, and the same committee in the guise of it paying some amount, the rest of the Sevites, or doing in some illicit way they are doing years after years, then state's intervention is necessary. We are for the state, we are for the Union of India, we are appearing. And the then Honorable Chief Justice Prakash Srivastava and Rajashri Bharadwaj, my lord, noted down again on January 30, 2023. Learned Council at page 15, it appears, Learned Council for the state as also Union of India are directed to file their reports in the form of affidavit within 3 weeks. It will also be open to Learned Council for other respondents to file their affidavit in opposition. If they so desire within a week thereafter, affidavit reply, exception, if any, be filed within a week. Supplementary affidavit on behalf of the petitioners filed today is also taken on record. Learned Council for the parties are directed to supply copies of such and such, etc. Therefore,
yes,
the only question remains when the state, by virtue of a judicial process, to keep the judicial harmony clean and so that a clean administration comes out, they are also interested, state government as well as the central government, because crores of money. My lord, that even whenever we attend to Delhi, my lord, being the member of the Supreme Court Bar Association since last 45 years, my lord, my experience is that yes, there are two things, therefore you are Goddess Kali's son. means Dakhineshwar and Kalighat. We are means it is beyond our knowledge, my lord, that the when means because of its strategic location, near to airport, near to Ganga, near to everything, and my lord, all the facilities, and also it is such a communicated one. It's, my lord, that the devotees, day by day, it is increasing to lakhs to crores. And there are all arrangements are going on by the government, state government, as well as the union government is answerable to it. Like the stampede in Kumbh. That means that one proposal before the Supreme Court was placed. That means that the states, when they are sending their people, they have to take responsibility in that because of their means language problem, etc., etc. Karnataki people die, they cannot understand Hindi. Hindi people they don't say. Therefore, all these things are going on, and it is on the desk of the Supreme Court to see all these things. Therefore, it is such an international sport. Can it be in these days? That means that it will be treated by one after another, means in the guise of means election. That means that some people will win over and some people will do, and at their dictate, that means the entire administration will go on, and crores of rupees will be infiltrated in this way. Is it not the my lord's conscience of it? Therefore, my lord, the very threshold, my lord, it should not be allowed to be taken into consideration. It will not be taken by this honorable court. This honorable court, my lord, even if my lord, this honorable court is desirous, then my lord, at your lordship's, my lord, that the sweet will, my lord, because of my lord, for giving administration, your lordship may ask for the chief justice at least to constitute a bench, and there your lordship can be a party there, at least so that means people will be helpful, society will be benefited, and my lord, that the entire citizens will get something, at least that whether good or bad. That is, I am saying, my lord, if the two benches are not in a position to it, your lordship may ask for it. That means that let it be parties to it, and also the means bench be found, but not alone. Not in this way, when they are, my lord, that is too complicated, my lord, the directions, and my lord, that they are doing in this way, my lord, even for a one day, the charge be given to them, my lord. Can you imagine, my lord, that the what fallacy will be there? My lord, they are selling it, my lord. We cannot show it, but we can see it. Something, my lord, that we can see all these things because we are the local people. That means that the 52 lakhs, 70 lakhs, they are selling all these things. And they are selling to the people, and they are doing businesses there. Who, why, how the authority they have got, whether the elected body can do it. If the High Court will interfere in the matter, then, my lord, High Court has some responsibility. High Court cannot ignore its own responsibility. That means that, well, even since 1986, when, my lord, we are crying for justice, my lord, in these days, after COVID, my lord, and, my lord, people are going to be allowed day by day. Therefore, my lord, why the division bench, my lord, that it be allowed at least to hear out it? And if your lordship means whether, if at all interested, then, my lord, that it means that yes, let it be part of it, then the bench be constituted, where your lordship may be a party, or rather, my lord, your lordship can advise it, advisory jurisdiction, your lordship has got it, because your lordship is also part of the public, part of the citizens, and your lordship definitely is a devotee, not your lordship, but my lord, your lordship's kith and kin. Cannot ignore. It is the Dakhineshwar, Kalighat. If the Kalighat, there is some public trust, district judge, my lord, because the DT in charge, district magistrate or judge, my lord. Why not a constitutional committee is created, if your lordship is so desirous, and let his very opinion in the advisory form be sent to the chief justice, and, my lord, the chief justice in his, my lord, judicial one. But, my lord, if your lordship pass some order which is adversarial to the public interest, then, my lord, whether it will not affect the public interest litigation, which has already been admitted, and, my lord, some positive directions have been given.
That's all.
Now, my lord, I will not, my lord, take much time from your lordship, because that already 12 is there, and here. My lord, at page 32 of their affidavit in opposition. Yes. In application 45, my lord, this is there. At page 32, my lord, if your lordship will kindly see, there it is, GA number 45. My lord, if your lordship kindly see, there, page 32, kindly have a look.
Is 32 up?
GA 45. In GA 45, my lord.
I thought they paying 40.
No, but law does not permit. I'm asking. Law does not permit when it is already on
Whatever
record
they
to
are.
take note of it. Permits. Then permit them, please. Don't shout it. Don't shout it. At least I can do all these things. That means what is going on. Why you are interested here, residing in South Calcutta? You are thinking of North Calcutta, keeping it. You are going Salt Lake, but you are predecessors also are. You cannot, we are.
Mr. Odhikari, make your submissions to the court.
No, it is not expected, my lord. That is,
Testing
my
time.
lord, to be very frank, my lord.
Please,
we-
please,
we
please
are-
go
we are-
ahead.
We are
Please,
from
please.
Naititto, Bhatpara Naititto. They are from the Tottotitto.
No, no,
And my lord,
don't
it is always, my lord,
don't make these
they
submissions.
are always. Office page 32, my lord, office of the director of income tax. My lord, kindly have a look.
Yes.
Kindly have a look, my lord. Office of the director of income tax exemptions. My lord, have your lordship got, my lord? If your lordship has got it, my lord, that is page 32. To the settler Lok Mata Rani Rasmani Foundation. My lord, kindly to the settler Lok Mata Rani Rasmani Foundation. My lord, the Lok Mata, means Rani Rasmani Foundation. Since 1986, by the order of the court, that for the administration of it is such, it will be done. And the same committee headed by Kushal Chaudhary is adorning the high seat of that committee, maybe for any reason whatsoever. Maybe as a good gesture or maybe for some malicious reason. I do not like to say it. But was it not his duty or the particular trust who has been entrusted by the Honorable High Court to deal with the administration of it out of the sanctity and wisdom of the courts? Whether it is not their wisdom, at least to bring it to the notice of it that we are going to form a Lok Mata Rani Rasmani Foundation. Is it clear? Another foundation. Is it possible, my lord? Can there be two entities in one entity who can work simultaneously without any disciplinary, without any permission from the, without any doing it, but at the sweet will, whim, caprice, and choice of the existing party? Therefore, all these things, when are
Yes.
on the bed, on the hot bed of the division bench, presided over my lord, that the Chief Justice, my lord, Honorable Chief Justice, and my lord, Honorable Chief Justice have been pleased to hear out the matter that well, there is some element of the public interest is involved. Then, my lord, is it not worthful? Is it not better? Is it not, my lord, that the sanctity and wisdom of the judiciary, my lord, means as per it, my lord, that the judicial discipline and decorum and the judicial harmony, my lord, that the division bench will do all these things? Because we see that excessive, there are so anomalies, and this is clear there. Income tax will not come with it, but my lord, honorable courts are there. Your lordships are next to God. My lord, we are crying for justice at the feet of your lordships, and your lordships are there by the grace of God. Your lordships are means adorning these high seats, my lord. If we are praying for it, my lord, to assist our juniors, my lord, is there any wrong, my lord? I am very grateful to your
Thank you.
lordship. Give me permit, my lord, kindly see, my lord, that only the division bench will do, my lord, not beforehand. If your lordships, my lord, that your lordship has heard the matter, my lord, that we will pray for it, my lord, that the entire matter is there. Later means bench be specially constituted. It happens everywhere. And my lord, this is, and there should not be any election, my lord, that in the meantime till the matter, because there is, my lord, end. There must have to be end to end, my lord. There must have to be complete end of this episode. Otherwise, my lord, that we are, my lord, we are very, my lord, very happy that, my lord, your lordship with a patientful mind, my lord, that your lordship has heard it, my lord, and then, my lord, I have instructed my juniors that I should not interfere. But, my lord, I am very happy, and my lord, I really, my lord, appreciate everywhere, my lord. That means that we are
Okay, thank
we are happy with such a, my lord, that
Thank you, Mr. Digar.
my lord, that he is a great jewel in our judiciary.
No, please, no certificates. বলো যে মিস্টার ব্যানার্জি কবে বলতে পারবে, ফ্রাইডে তো তাহলে নিতে পারবে।
I'll finish today.
Huh?
I'll finish whatever I can.
12:30 I have witness actions and all. So 10 minutes, I think 10 minutes will not be possible for you.
Another 10-15 minutes I'll finish. I don't want to give other.
Oh.
This is only
No,
a
no,
strategy
no.
tactics.
I have been sharp master the loss. I have already
That's why whatever happens, I'll finish up.
I will tell nobody file. If your loss is starting.
I'll take that. May I take 43 1? For a confession, I had our copy of the PIL, I've got another copy.
আচ্ছা ওটা একটু দিয়ে দিন
Who's the PIL?
এটা দিয়েছে মানে দিয়ে দিলাম মনে হচ্ছে দেখো তো নিচে আছে কিনা কপি করলো কি কপি তো ওনার কাছেই আছে কপিটা ওনার কাছেই আছে মিস্টার ব্যানার্জি দ্য কপি ইজ উইথ ইউ পিআইএ
এটা আমি এখন hand over করবো।
হ্যাঁ দি অরিজিনাল
যেটা Oh, yeah, Lakshmi.
Yes. Give a copy of them. Both are taken up together by the division bench.
Item number 40, number 43 minute. But who has filed this petition? This petition has been filed by one Snehanshu Chaudhary.
Forty-three. You are
43.
filed by one.
Snehanshu Chaudhary.
Our plan.
But what is voting right in the entire matter? His voting right is 6 by 2625.
Six by
6 by 2625. That is 0.23. He's a Shebite,
yes.
recorded since 1986. I asked myself this question that he is so concerned, he has come to this court. Very good question. But why doesn't he express his concern in discharge of his duties of a Shebite?
Mr. Odhikari, please, this is a request from the court. Let Mr. Banerjee argue. This is that is up to you. Yes.
Discharge his duties. I'm grateful to Mr. Haldar for having placed J number 44 and the deed of trust of
The G44.
it is in J 44, page 17, Mr. Haldar, please.
Page number
17, clause 10. Mr. Haldar, please. For your lordship.
the scheme.
Yes, the scheme. The secretary shall exercise general superintendence over the affairs of the trust and shall have keep proper accounts of all moving properties and in progress and deliver the funds. Maintain proper records in their functions. Keep proper receipts. Allow inspection by the Shebite during the day at such 6 hours as the secretary is not obliged to be absent from his office of duty. May I ask myself this question? This gentleman who Mr.
Snehanshu.
The applicant in 43 He's a Shebite since 86. How many times has he sought inspection of the accounts? He's very concerned in court.
Yes.
Number two, as a Shebite, he's entitled to inspections.
Yes.
He could have seen the accounts, pointed out before your lordship that accounts have not been properly maintained, not just bold allegations, gross misuse of powers, gross misuse of funds, gross misuse. Where is that evidence before your lordship? In all these evidence applications, has a single piece of evidence been brought before your lordship? They are Shebites, they're all entitled to inspection, they can all see the books. Nobody has bothered. Because they know very well that if they take inspection, they won't be able to find a fault.
Yes.
Not only this particular temple trust, an income tax assessee. It is not one of those trusts which have applied for exemption. That temple trust has a PAN card. It has a PAN number because it files returns every year. If your lordship wants, I can also tell your lordship the PAN number. If your lordship so desires, I have the PAN card. Not only that, even the income tax department has done scrutiny of accounts. Never we have had a problem.
Yes.
Every year, 2 rounds of audit happen. One by the internal auditor, one by the statutory auditor.
Yes.
Obviously, they will not take inspection. They'll find out these things. Then they can't make these reckless allegations. That then, I heard a submission was made before election that no accounts are maintained. Again, I am saying. I did not interrupt anybody.
Yes.
The Shebites have not performed their duty, the petitioners before lordship, of trying to even find out, exercise their right as a Shebite of taking inspection of the books of accounts. Because they know that they cannot do anything. They attend meetings. I'm not saying other things. But I believe in dignity of court. And go away.
Yes.
This entire allegation is of misuse of funds is entirely baseless. And they could not prove a single piece of evidence. It was all there open for them to see it. They could not, they did not. They, after having failed in your duties, and you point a finger at somebody else, why are you a Shebite? You are a Shebite to ensure that nobody does anything wrong also.
Yes.
But a number of times it was mentioned before your Lordship today that there are 600 Shebites who are before your Lordship. Let us take a calculation of the portion, percentage of the Shebites over here. This gentleman has 0.23, which is 6 by 26. And the other gentleman who has, with Mr. Vikramjit Das, who is the petitioner in GA number 44.
Hmm.
He has 1 by 126.
Hmm.
That is 0.79. Similar today, together, this subject to correction in mathematics, it's about 1%, about 1% plus. So 99% Shebites don't have a grievance.
Yes. Vikramjit is also since 1986.
So, PAN card for income is
No, I'm asking Vikramjit is also recorded as Seva since 1986.
he came after because see, his father died, then he comes in.
Okay.
So but he has come in at the later date. I'll tell you what we change. But he's been there also for some time now. That because only after the death of father,
Yeah,
the
that
son
legally
will
yes
come
comes.
and whoever has whatever portion of it, the children will have accordingly divided by the number of children that much portion. So that's why. So on this ground, that there is cross defalcation of funds, cross of power, cross everything else wrong. Not a single piece of evidence has been shown, which they could have in the usual course collected. I can talk about somebody else who does not have access. But these are people who had access, but they could not still produce a single piece of evidence. And on the contrary, I say that all my accounts are audited, not once, but twice. One by the internal auditor, and on second round by the statutory auditor. And I file income tax return sees everything. But another, but Vikramjit is from the year 2012, 13.
Yes.
That is also a fairly long time. Now, Next page. So as far as accounts are concerned, there is nothing. Lot is said about the public interest. Mr. Odhikari says that we have suppressed, but not know that in their application, it was asked about the orders which he placed before election. In fact, he suppressed by not placing all the orders. Now, may I take my affidavit in opposition? 43.
Yes.
7 November 22, page 7, I'm sorry. 7 November 22
Yes.
is the order by which the records of CS number so and so and orders passed in were directed to be produced. Next, 20, next order is
If-
5th December 22, page 9.
Yes.
When it comes for the respondent has submitted that he has already applied for a certified copy of the pleadings and relevant orders, but the servant not apply. This is not very important. Next, 20th December 22. Learned counsel for the respondents have certain preliminary objection as to the maintainability of the present public the interest litigation. Hence, they are permitted to file affidavit in opposition, confining it to the issue of maintainability of the petition within a period of 4 weeks. Thereafter, affidavit reply, if any, within 1 week. So, open to the learned counsel, the respondent to place on record the copies of the pleadings obtained by him in the pending suit. Next, which there is 30th January 23.
Yes.
Affidavit in opposition on behalf of the trustees of Doar Kali Temple and the Deportor estate to files today pursuant to the earlier order is taken on record to be filed our affidavits before the chief. Learned counsel of the petitioner seeks 2 weeks time to file his affidavit and reply in response to the affidavit of opposition filed today. Learned counsel of the state and the union are directed to file their reports in the form of an affidavit with 3 weeks. It is also open to the learned counsel for the respondents to file their affidavits in opposition. If so, desire within a week thereafter, I will also exception. Supplementary affidavit taken. Next is not 14th March 23. Page 16.
Yes.
Learned counsel for the petitioner prays for adjournment on the grounds of illness of the arguing counsel. Time to file the affidavit in terms of previous order is extended. It was default on the part of the petitioners to file their reply and their inability to proceed with the matter. They were the petitioner, they had the carriage of proceedings. Since then, since this date, 14th of March 2023, who has the carriage of proceedings? The petitioner. What steps have been taken to have this petition heard, this public interest petition heard?
Yes.
I ask myself this question. My application is for holding a meeting because the trust has to continue. Management of the trust has to continue. It's got nothing to do with the issues involved in the bill.
Yes.
Let the court first decide that it is a public trust. Then everything will go, obviously. But the court has to come to that finding.
Yes.
You know, the lot of submissions that are made. Huge, huge amount of money is being paid by the central government and state government. They are Shivites. They have got access to the accounts. I can't argue. Like this is the how I'm going to be disturbed from the side. This is very unfortunate. I didn't do any of this. I'm not to respond to the counsel of the others. But if constantly from the side this happens, it becomes very difficult.
Mr. Odhikari, once saying I am requesting you, please don't pass any comments. Let him argue the matter. Thereafter, we'll see. Yes.
But today they had. I asked myself if they had been able to produce a single bit of evidence about funding by the central government and the state government. In the petition below, a submission was made.
Which in GA? 44?
44. Yes. In the petition in 45, why don't we kindly come to page 8?
Yes.
A submission is made over here. The applicant craves leave to a video clip of the Secretary of the said trust in the presence of the Honorable Chief Minister of West Bengal with regard to acknowledging 130 crore rupees from the public exchequer at the time of hearing if necessary.
Which paragraph are you reading?
Page 8, just last few lines of page 7, paragraph 7.
Yes, yes.
This submission is made in the petition, which is affirmed. $130 crores from the public exchequer. Then they are Shevites. It should be reflected in the books of accounts.
Yes.
With greatest of respect, my humble submission to your lordship is cash comes from India and all the state of this. None of them are one second. As far as the yes, I would say the central government under the Ganga Action Plan has renovated the banks of the Ganga, repaired the ghat, made the jetty, but that is under the Ganga Action Plan. Let my learned friend show that any fund has come from the central government to the trust. No fund.
Plea.
Number two, as far as the submission was made, as far as the guest house is concerned,
Hmm.
with whose permission was this? Then I say, when Shivites do not do their duties and reckless allegations are made, it's very unfortunate. May I show to your lordship? But order dated 17th May 2010. 2010. My lord will kindly come to phase 3 involves construction of a multi-plaza building, and the aforesaid will ensure to the benefit of the estate. Accordingly, order in terms of praise ABC of the notice of. With the leave of court, this guest house was started. As I said on the last occasion, if any work is to be done, major work other than the normal day-to-day, we have to come to this court and seek permission. And even while making that, was specifically the entire development plan, phase 1, phase 2, phase 3, was brought to the knowledge of the court. And completion of phase 1, phase 2 was done, brought to the notice of the court. Court approved it. And then phase 3, and which is for this multi-plaza building. They call themselves Shivites, interested in the temple. Nobody wants to know. Because these are not issues they want to find out or be interested in. They only want to come here at the time when we come before the Lordship for election, how to scuttle the entire issue. Because they are not people who go for the benefit of the temple trust. I say these very strong words.
Yes.
Next. As far as the skywalk, which is constructed, which is for the, but that is not on the temple land. It is on the state government road. The state government did a skywalk because we said that we are facing a lot of congestion over there. We requested either broaden the road or do any other thing. The state government constructed the skywalk. Cannot help it if we don't. Or it is on the road, above the road, the entire skywalk is situated. So that people, pedestrians can walk down without being disturbed by cars.
Yes.
I ask myself that what is the work that state government's money has happened? Nothing. There is no such money. This guest house was started by the temple trust. But we were not able to do it to our satisfaction. So therefore, the construction was held up for some time.
Yes.
Thereafter, the government of West Bengal came forward. They said, why are you not able to do it? We said, because of funds, we are gradually doing it. KMDA was appointed. Not us, not a single penny came to the trust. KMDA finished that project. Still finishing is going on. Not a penny has come into the trust. Submissions are made, reckless submissions are made. That money is coming into the state government. Sheboyts don't do their duty. They come and make submissions.
Yes.
Yes. I'd be, although it was not placed with your lordship, but I on my own, because I want very clear to your lordship's conscience. For the first time, queries were raised by one of the trustees, or one of the Shebites, which is in page GA number 44, Vikramji,
29 January.
29 January. And if your lordship looks at page 55, when was this particular article delivered, letter delivered, according to their own? Page 55, my lords, it's the India Post tracking. The first one, my lord.
Yes, yes.
Item delivered. It's on 1st of February. The letter was received by the trust. And when was this petition affirmed? Fifth. 5th of February, the petition was affirmed. Yeah. This is the letter on birth. Within 3 days, 5th petition filed. So it is only for the purpose of this petition that this letter was sent. They did not place it. I wanted to be very clear to my conscience.
Hey. Hold on. Witness কি আছে? কন্টিনিউ করতে হবে, লোক এসছে না। উইটনেস তো শরীর খারাপ হয়ে গেছিল, কন্টিনিউ করতে হবে। বলো নেক্সট ফ্রাইডেতে করবে। ফ্রাইডে থাকবে না। প্রীতমকে বলে দেবো যে ফ্রাইডে শুধু এই ম্যাটারটি রেখে দেবো, তাহলে আমি কনক্লুড করে দিতে পারবো। Mr. Banerjee, can you come back on Friday? On Friday,
Tomorrow, it is not possible.
Tomorrow also can. Tomorrow it will not be possible. ওখানে আছে। Friday morning.
10:30 I'll be there.
Yeah.
Because for Friday, similar for 10 days, I will not be in Calcutta. That is why I'm saying.
Friday evening it.
Friday, if it's fixed at 10:30.
আমি দুটোর সময় যদি এটা নিই।
It might not fix 10 minutes. I will not take long, but if my lord, the other side takes time, then they will ensure that it's not.
I have applied the advance.
When are you to leave? When are to leave? When are you to leave? Evening. So second or first একদম টপে রেখে দিই।
I have already had a meeting with the opposition since I have decided copy of this particular. So, lordship permit, I in the opposition, my lord. Because of that, both
Can I come back at 2 o'clock? Once, because I will 12:30, your lordship has suddenly, or 3 o'clock, whenever convenient to your lordship.
The appellate side matters will be taken up too. On Friday. On Friday 2 p.m.
Because I am scared again by Friday, another 3 applications will come. Because the lordship, the 0.2, 0.1, all these people will come in. This is a cartel operating, my lord. And every time, may I say this year's people, next year will not come. Next year's people will be another. Last year's people have not come this year.
not on record. Because of that, they have suppressed, deliberately suppressed the peace.
Again, you have submitted. We are on which date we'll take it up?
Your Lordship, kindly only when I bring to an end, because otherwise, my Lord, I'll be very.
I'm trying to.
I realize, but that is the problem. Your Lordship, remember, I told you, Lordship, the first day.
So they have filed application. I have listed it
This
today.
is what happens. Because this is my experience that the applications will be made just to ensure that the order is not passed.
Application direction chalo. You have given a copy of the opposition. You have.
No, I hearing now,
এটা নিয়ে নিও আপনি যদি এটা হয় কিছুটা একটু কভার করে দেবেন whatever submissions of opposition you cover on the next day.
Yes, I will. Because I have.
42
May I say this? I have not made any allegations in 42.
No.
It is only procedural. I'm
40
asking for.
GA 42 of 2020 24. Mr. Pankaj Haldar, learned advocate for one of the Sebayats, seeks leave to file affidavit in opposition. Leave granted. Affidavit in opposition filed on behalf of the one of the intervener Sebayat is taken on record. Copy served. Leave, ওখানে করুন it seeks leave to file affidavit in opposition as well as vokalatnama. ওপরে করুন leave granted. আচ্ছা 40
লিখটা লিখে দিচ্ছি আপনার ফরম্যাটে ফাইল করবেন
43 44 and 45 এই তিনটে দিন argument on behalf of the petitioner is concluded.
টাকা দিয়েছে তো?
Third, Mr. Amitis Banerjee, a senior advocate, appearing for applicant in GA 42 of 2024.
না না, তো সেবাই তো অ্যাকাউন্ট থেকে বলে
Due to paucity of time, the hearing could not be concluded. List this matter
কোর্টে
on Friday, 14th at 2 p.m. Copy করে দিন। এই অঞ্জন বাবু একটু খেয়াল করে প্রীতমকে বলে দেবেন যে ফ্রাইডে তো এই জিনিসটা হবে না, ফ্রাইডেতে আমি অরিজিনাল সাইড নেব, যেটা বলেছিলাম পুরোটা নেবো অ্যাপলেট সাইড, ফ্রাইডের ক্ষেত্রে নেবো না।
one and a half hours there only we have.
You cannot complete within that period. You cannot complete that within that period.
I will finish it in 10-15 minutes. But
They-
thereafter,
Mr. Haldar will take-
longer, 3:30, 1 hour is. They're all
Just
very
5
knowledgeable.
minutes and you say 10 minutes, so 15 minutes we can wrap up.
Let us see. I will not take more than 5.
Let's see. Come.
commercial bench
Commercial bench. To be mentioned, item number 1. This suit has been settled, my lord. My lord, the terms of settlement, your lordship will see. It has been signed by the parties, my lord.
Who are for the defendant?
কোর্টে নিয়ে যান এটা নিয়ে যাবেন
He is appearing for defendant, actually defendant.
স্ট্যাম্পটা মারিয়ে দাও স্ট্যাম্পটা মারিয়ে দাও স্ট্যাম্পটা মারিয়ে
Parties have filed.
It has settled between the parties.
Your lordship can pass a decree on the basis of this.
Terms and conditions.
It was a suit for eviction, my lord. Lordship had-
GSA রেটা এসছে? পেপারস গুলো এসে গেছে?
Terms of settlement, your lordship have filed.
Where is the terms of settlement?
Lord, your lordship will see page number. It starts from page number 2, my lord. By consent of the parties, my lord, suit stands disposed of on the following terms. 1, my lord, the defendant shall vacate. Page number 3, my lord. Right. Page number 4, and in the end, my lord, it has been signed by the parties, their respective advocates, my lord. I have also signed as advocate on record for the plaintiff. Page number 4, my lord.
Oh, this is the terms of
This
settlement.
is the terms of settlement.
And what is this?
But this is authority because my client is three companies, my lord, and they are government
Yes,
company,
your
my lord.
lordship.
So, my lord, all the authorities have been signed, filed. Although they have been filed in the suit register, but still again we have filed.
You are representing all the defendants.
Only one defendant,
Only defendant, your lordship.
one plaintiff, one defendant. So, suit for eviction.
Yes, yes, yes.
Matter is appearing under the heading to be mentioned. This is a suit for eviction of the dependent tenant which is the premises number.
That is also provided in the terms of settlement, my lord. Goho Estate, my lord. Your lordship will read.
Ah.
Clause 1, my lord.
Hmm.
Premises located at Goho Estate.
For
7
eviction
Ganesh-
of dependent tenant from the premises located at Guho Estate, 7 Ganesh Chandra Avenue, Kolkata, 70013. Para. Mr. So and so learned advocate appearing for the plaintiffs as well as the learned advocate for defendant submits that during the pendency of the suit, settlement has been arrived at between the parties and a terms of settlement has been prepared and signed by the plaintiffs as well as the defendant
on 27th January.
on 27 January 2025. The terms of settlement dated 27 January 2025 filed in court is taken on record. Both the parties praise for decree in terms of the terms of settlement. Peruse the terms of settlement. Stop. Para. Considering the aforesaid and the submissions advanced on behalf of the parties, let decree be drawn in terms of the terms of settlement. The suit being number CS Form of 39 of 2024, old CS number 105 of 2007 stands disposed of. Order as to cost. Decree be drawn expeditious.
Deeply, let us lodge.
Item number 2.
That our instance, my lord, during
That
the
is-
time of draft up of the decree,
Heading-
one correction.
The heading to be mentioned. Well, you filed an application,
My lord, kindly sees, my lord, internal page 8, my lord.
but I think this was, you have given a calculation sheet. In that sheet, you mentioned the date of filing of the suit to be 1st October.
Lordship is correct, but my lord, the record
I
show
think that
that the plate has
word's
been
date
admitted.
of filing of the suit should be deleted. Because
Yes,
your
absolutely.
claim is from September till September.
30th September, it's calculated, and thereafter from 1st October.
So on last page, that has to be deleted.
My lord, this words, the date of filing of the suit, that is. My lord, up to here, if it is deleted, then my lord, it is my lord, according to me, my lord, proper.
In the body of the judgment, is there anywhere it is stated of that particular?
Regarding filing of the suit, my lord.
Yes, yes.
My lord, I did not find that, my lord, in the body of the, my lord, judgment.
Okay. Appearing under the heading to be mentioned. Mr. Rajarshi Dotto, learned advocate for the plaintiff, submits that the words, sorry, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. The words at page 8 in 15th line of the judgment, that is within inverted comma, date of filing of the suit, that is to be deleted, since 1st October 2001 is not the date of filing of the suit. Upon perusal of the judgment, it is found that a typographical error has crept into page number 8 at 15th line, mentioning the date of filing of the suit, that is, mentioning the words inverted comma there, the date of filing of that is. The aforesaid words, yes.
I notice one more thing, my lord, subject to my lord lordship permitting.
Yes.
Lordship's, my lord, direction for payment of interest is till 8th of January. So, my lord, when I file execution, my lord, I have to restrict it to 8th of January, even if, my lord, they don't, my lord, future interest is not provided for. Till realization, usually, my lord, the
A table created problem.
I'll leave it, my lord.
Thank you, William. And words is stands deleted. The interest granted on the amount decree should be from 1st October 2001 till realization of the entire amount. The aforesaid decree, the aforesaid judgment is modified to the above extent and forms part of the judgment and order dated 8 January 2025. Decree be drawn accordingly. It is hard to.
Witness action, item number 3.
I'm appealing for the plaintiff. But
Plaintiff's witness.
my lord,
Plaintiff's witness.
yes, my lord, but we'll seek an accommodation today, my lord. I'm seeking an accommodation to enable the plaintiff.
Sir. Mr. Devdut Mukherjee, learned advocate for the plaintiff.
My lord, may I just indicate why I'm seeking the accommodation, my lord?
Uh.
My lord, the name of the defendant number 2, my lord, has changed. I have got the document from the Ministry of Corporate Affairs, my lord. I need to take out an amendment application.
You are for?
For the defendant number 1.
Oh. 2 has to be corrected.
My lord, yes, the name has to be from PMS. It has
Mr.
become
Devdut
colossal. My lord.
Mukherjee, learned advocate for the plaintiff, submits that the name of defendant number 2 has changed as per the certificate of incorporation issued by the Ministry of Corporate Affairs, Government of India. He seeks to take out an appropriate application for amendment of the name of defendant number 2. let the matter go out of list with liberty to mention. After you file that application, you mention
I'll do
that
it within the next 7 days.
after that it will be listed. এটা থাক।
Item number 4.
Your witness was doing cross-examination. Now he is all right, Mr. Banerjee, your client.
Start now, my lord. It was started 2.
It will continue. How long you will take?
My lord has
Appellate side.
might finish also.
তার বক্সে চলে আসো। একটু এক্সটেন্ড করে দিলে হবে।
What is your name, sir?
দেবাশিস সাহা।
দেবাশিস সাহা। আপনি বাংলায় বলবেন? আস্তে আস্তে ছোট ছোট করে। দেবাশিস স্পেলিংটা বলুন।
DEBASISH।
Yes, sir.
Mr. Shaha, in your evidence and affidavit, you have referred to certain letters by which you have purported to make complaints about the dilapidated condition of the suit premises and have also referred to certain other losses and or expenses that you have suffered or incurred in respect of the suit premises. Have you made any monetary claim against the plaintiff in this regard?
আপনার এফিডেভিট অফ এভিডেন্সে আপনি কিছু পারপোর্টেড কমপ্লেন করেছেন ওই স্যুট প্রিমাইসেস এর খারাপ অবস্থার জন্য এবং আরো কিছু। এই জন্য কি আপনি কোনো মনিটারি ক্লেম করেছিলেন?
না।
নো।
ওনার অ্যাফিডেভিটটা দিন।
তো দিয়েছেন?
নো। আনসারই নো, স্যার।
Have you annexed any documents corroborating the fact of such alleged damage and or losses suffered by you?
আপনি কি কোনো রকমের ডকুমেন্ট এর সঙ্গে যোগ করেছিলেন যেটাতে দিয়ে আপনার লস বা ড্যামেজ কি পরিমাণ হয়েছে সেটা বোঝা যায়, যা থেকে বোঝা যায়?
না, এটাও করা।
নো, আই হ্যাভ নট অ্যানেক্সড এনি সাচ ডকুমেন্ট।
Have you filed any independent suit against the plaintiff wherein you have sought to be compensated for or reimbursed for such loss or damage?
এই লস, আপনার যে লস হয়েছে সেটা রিএমবার্স করার জন্য আপনি কি প্লেন্টিফের এগেইনস্টে কোনো স্যুট ফাইল করেছিলেন?
না।
নো।
নো।
I am putting it to you that all these allegations made by you in your evidence and affidavit are of no consequence and no reliance can or should be made thereon.
উনি আপনাকে সাজেশন দিচ্ছেন, আপনি মানতেও পারেন নাও মানতে পারেন। উনি বলছেন যে আপনি আপনার এফিডেভিট অফ এভিডেন্সে যে সমস্ত অ্যালিগেশন এনেছেন সেগুলো বিশ্বাসযোগ্য নয়, সেহেতু তার উপর কোনো রকম মানে আগামী প্রক্রিয়া করা যাবে না।
না।
আপনি ওনার সাথে সহমত নন, তাই তো? আই ডিসএগ্রি। এবার যদি আপনি কিছু বলতে চান বলুন।
যখন কোম্পানি প্রেমিসেসে হয়েছিল রিপেয়ার করার জন্য কিন্তু তাদেরকে লেটার দেওয়া হয়েছিল।
কোম্পানি প্রেমিসেসে
যেখানে আমাদের অফিসটা ছিল সেইটা যে ভেঙেছিল সেইটাকে সারানোর জন্যই কিন্তু
where our office is situated, it was in dilapidated condition. To repair this, বলুন।
হ্যাঁ, রিপেয়ার করার জন্য তাদেরকে বলা হয়েছিল। আমরা
তাদেরকে বলতে কাকে বলুন?
যে ওনারকে।
The owners were requested to repair the premises or dilapidated condition of the office. বলুন।
এবার তারা এটাকে রিপেয়ার করেছিল।
They repaired the office.
ভেঙেছে।
Let me answer that. Right. He said this is never the case made out by him in the letter, or he never deposed that it was in a dilapidate condition. He said certain damages were there. He was asked to do it.
Damage condition.
Damage. ওরা রিপেয়ার করেছিল, হয়ে গেছে।
ওরা রিপেয়ার
আর
করে
কিছু বলবেন?
না।
What was the last paid rent that you paid in respect of the premises?
আপনারা লাস্ট কি রেন্ট পে করেছিলেন? সে সর্বশেষ যে রেন্টটা ভাড়াটা দিয়েছিলেন সেটা কত?
এটার জন্য তাহলে আমাকে একটু ফাইল দেখতে হবে, কারণ আমি অ্যাকাউন্টস এর
I have to check.
কিন্তু আমাদের
I have to check the records to say that. বলুন, এবার বলুন।
আমাদের সমস্ত আমরা যখন রিলিজ করে দিই,
কি রিলিজ করে দেন?
মানে আমরা চাবি যখন হ্যান্ড ওভার করি, সমস্ত আমাদের যা ডিউস ছিল সব আমরা পেমেন্ট করে দিয়ে আমরা রিলিজ করি।
When we release the keys, hand over the keys, we cleared all our dues. We have cleared all our dues.
এবং তাদের তরফ থেকেও কিন্তু তাদের যে ডিউস আছে আমাদেরকে কিন্তু কোনো চিঠি দেওয়া হয়নি।
And from them no letter was given to us claiming any such dues. Any more dues করে দাও।
I suggest to you that the tenancy in question, created by the agreement dated 7th May 1984, stood terminated by the notice dated 19th of July 2008.
উনি আপনাকে সাজেশন দিচ্ছেন 2012 উনি আপনাকে সাজেশন দিচ্ছেন যে 7ই মে 1994 এর যে টেনেন্সি এগ্রিমেন্ট ছিল সেটা টার্মিনেটেড হয়ে গেছিল 19শে জুলাই 2000 মে
2008.
May-
July 2008.
19শে জুলাই 2008 এর কি ছিল নোটিশের দিয়ে ওটা টার্মিনেট হয়ে যায়, যেটা এগ্রিমেন্ট ছিল, টেনেন্সি এগ্রিমেন্ট ছিল।
কিন্তু ওখানে টার্মিনেশনের কোনো ক্লজই ছিল না।
there were no such termination clause.
I suggest to you that you have wrongfully occupied the suit premises from expiry of the notice period, that is 1st September 2008, till the surrender of possession on 29th September 2023.
কোশ্চেনটা আস্তে আস্তে বলো। আপনারা অন্যায়ভাবে ওই স্যুট প্রেমাইসেসে থাকছিলেন বা জবরদখল করেছিলেন নোটিস পিরিয়ড এক্সপায়ার হয়ে যাওয়ার পর থেকে, যেটা কিনা নোটিস পিরিয়ডটা শেষ হয়েছিল 1 সেপ্টেম্বর 2008-এ, এবং তখন থেকে 29শে সেপ্টেম্বর 2008 পর্যন্ত আপনারা ওই 23 পর্যন্ত আপনারা রংফুলি ওই স্যুট প্রিমাইসেসটা অকুপাই করেছিলেন। আপনি ওনার সাথে সহমত না সহমত নন?
না, কারণ টার্মিনেশন
disagree.
ক্লজটাই তো নেই।
Because there was no such termination clause.
I am putting it to you that the plaintiff is entitled to its claim in the plaint as made from 1st September 2008 till 29th September 2023.
কোশ্চেনটা আস্তে আস্তে বলো। আস্তে আস্তে প্লেন্টিফ ইজ এন্টাইটেলড টু হিজ ক্লেম। প্লেন্টিফ ওনার ক্লেমটা এন্টাইটেল পেতে পারেন আর কি, কারণ তারা প্লেন্টে এটা উল্লেখ করেছিলেন 1 সেপ্টেম্বর 2008 থেকে 29শে সেপ্টেম্বর 2023 পর্যন্ত। ওই সময়টার জন্য তারা ক্লেম পেতে পারেন।
মহামান্য কোর্ট যে
আপনি ওনার সাথে মানে সহমত না সহমত নন আগে বলুন।
এ ব্যাপারে আমি পুরোপুরি মহামান্য কোর্টের কাছেই প্রেয়ার করব, উনি যা ডিসিশন দেবেন সেটাই আমরা মেনে নেব।
I will leave that decision to the learned court. Honorable court.
I am suggesting it to you. I'm suggesting it to you that the evidence which you have led before this honorable court is incorrect and cannot be relied upon.
উনি আপনাকে সাজেশন দিচ্ছেন যে আপনি কোর্টের সামনে যে সমস্ত তথ্য প্রমাণ দাখিল করেছেন সেগুলো ভুল এবং মিথ্যে এবং বিশ্বাসযোগ্য নয়, সেহেতু
না,
I disagree.
kindly fix it for arguments after some time so that we can come prepared.
Cross-examination of witness Mr. Debashish Saha, Assistant Manager, National Insurance Company Limited, is concluded. Mr. Shiv Shankar Banerjee, learned advocate appearing for the defendant. You will not be adducing any further evidence? No.
Sure. Lordship, if I, no, Lordship can keep it in a to be mentioned next week, any day, and thereafter we will fix it for.
Submits that he needs to take instruction as to whether any further evidence will be adduced on behalf of the defendant or not. Is this matter next week to be mentioned? 18th.
Very grateful to you.
I'm ready.
Any.
Next was mine, my lord. I was to file my affidavit in chief. There's a delay, my lord, first, and then there is this order of your lordship's application. The name of the defendant has not yet been corrected by the department. Despite
Amendment was carried out.
no, my lord. The order was the registry of this court is directed to correct the cost title of the. This is the order of 8th January, my lord.
Title for the cost title.
Last paragraph.
Oh. Yes.
That has not yet done. Because if your lordship sees the list today, still
এটা অঞ্জন বাবু এটা একটু দেখুন ডিপার্টমেন্টে একটু বলে দিন এটাকে চেঞ্জ করে দেবে এই যে এটা আসুন
and another request, my lord. I was to file my affidavit in chief, my lord. I couldn't prepare it, my lord. Gives me 3 weeks time, my lord. I'll do it and come.
who is for the defendant?
Then the Chakraborty who was up. To এদিকে আয়.
This matter is appearing under the heading Witness Acts. Mr. Mohit Gupta, learned advocate for the plaintiff, indicates that the name of the defendant has not been corrected in terms of order dated 8 January 2025. The registry is directed to correct the name of the defendant in terms of order dated 8 January 2025. Next, Mr. Gupta, learned advocate for the plaintiff, seeks accommodation to file affidavit in chief of the plaintiff's witness. None appears on behalf of the defendant. Release this matter after 3 weeks. But sorry, time to file affidavit in chief of the plaintiff's witness is extended for a period of 3 weeks. Release this matter after 3 weeks. No. Tomorrow we'll see.
May I permit to mention for upgradation, my illegal unlawful consumption, my island.
Afterwards. Not, no obligation right now.
Otherwise, my actually
Come on, come. Yes, next week.
For correction.
What correction?
Manner previously recognition has passed order. Name was mistakenly wrong recorded.
এখানে কেন? Oh, what is it? Justice Kapoor is open mention.
Last week I was mentioned this matter, my lord. Item number
I'm-
364 of the combined matter list, my lord. Your lordship directed me to mention this week. That's why only.
I have mentioned before his lordship Ravishankar Kapoor, he said go to the regular bench.
Very urgent
I
matter,
don't-
that's why I mentioned, otherwise I am not disturbing your lordship list. 364 of the combined matter list. I was mentioned the matter.
Common monthly list.
Your lordship directed me to
This
mention that.
affidavits, everything is complete in this.
Everything was complete. Everything was completed, my lord, affidavit was served, but state filed their report. We have filed out explanation, everything was the only your lordship only take up the matter, is a short matter, my lord. Within 5 to 10 minutes, your lordship only, my lord, dispose of the matter.
দেখো আমি একটু combined monthly list
That matter, sir. 364 of the.
Who is on the other side? State.
He was appearing for other side, and one of them, Shobik Shah, he was appearing for the Malad Pradhan Malad. 364. I was served the notice with notice, Malad, I mentioned. Malad, here is the notice, Malad, with notice I mentioned the matter. 360.
360 for the returnable motion.
Returnable motion.
Rus-
Notice, Malad, I mentioned.
Rustom Mondol.
Yes, Malad. Rustam Mondal.
मतलब 440
Doctor.
same matter.
Take to the.
Upon notice,
Yes.
my answer মন্ডল মানে I After notice.
বলে দি। Kindly, Malad.
এটা নিন একটা হিয়ারিং লিস্টে দিন অ্যাফিডেভিটস আর কমপ্লিট
Everything was complete.
ওটা হিয়ারিং লিস্টে নিয়ে যান হ্যাঁ
Your lordship can pick the date, Malad. Your lordship.
ওটা
kindly
হিয়ারিং
pick the
লিস্টে ডেলি লিস্টে নিয়ে এসো
date. Any.
আর রিটার্নেবলে রাখবেন না হিয়ারিং লিস্টে নিয়ে আসুন করুন কাল পরশু ডে আপনি কালকে রাখবেন না ঠিক আছে এটাকে হিয়ারিং ওখানে অ্যাড করে দিন অ্যাড করে নিয়ে আসুন হিয়ারিং লিস্টে আমরা টাইম করে নেবো
Your lordship can let the matter be appealed as to be mentioned, your lordship can fix any date.
No, what I'm doing is, since the affidavits are complete, I'm also preparing a list which is the matters which are ready for hearing. So after returnable motion, I will go into the hearing list. It will be listed under hearing list.
Yes.
That's why I asked you whether the affidavits.
Under the hearing, Malad, their matter will not be taken up. Your lordship, that's why.
No. What I am into is, for some time I will be taking a returnable motion and thereafter hearing matters.
Otherwise, your lordship can fix only one day as for hearing.
Let it come up in the hearing list.
Yes.
Thereafter, we'll see.
Yes.
May I permit to mention? But this matter was taken up for hearing on 16 January 2025 by the earlier bench, my lord. My lord, the lordship directed that the matter would be listed on 29th January 2025. It was not listed, my lord.
It নিয়ে নিন
My lord,
এটা কি মোশন না কিছু আছে লিখেছে মোশন মোশন আর রিটার্নেবল মোশন রিটার্নেবল লিখে না মেনশন করে দেবে রিটার্নেবল মোশন নিয়ে নাও অ্যাপ্লিকেশন
my lord,
Restoration application, my lord.
my lord,
Manner
my lord, praying for inclusion in the
This matter was heard by Honorable Justice Provision Kapoor matter, the matter is secondable on 14th February matter. Because an urgency matter, my approach road to the main road is completely blocked by the private respondent matter. This is the only urgency matter. I'm mentioning upon notice.
মোশন
Secondable.
লিস্ট কর
same pure my lord, general motion, my lord.
এটা it is appearing in the list no আচ্ছা এটা লিস্ট করে
And same pure my lord, general motion, my lord.
give notice
Extremely like my senior citizen, my lord. Lordship kindly-
notice given
the earlier bench.
My lord,
notice দিয়েছি কিনা দেখ
what is this?
who is on the other side
My lord, urgent matter, praying for inclusion in the list. My lord,
answer
urgent
Mondol.
matter.
This affidavits have been filed in this
Yes, ma'am, completed, ma'am.
এটাকে হিয়ারিং লিস্টে দিয়ে দিন
My lord, urgent matter, praying for inclusion in the list.
Motion.
My lord.
Motion.
No, it is actually bearing matter.
Is it a
Pon-
motion?
Panchayat.
Yeah, motion.
Hearing.
Hearing. Affidavits exchanged.
Yes, my lord.
Okay, no.
My lord, urgent matter. It is very urgent matter.
First, tell me whether it is returnable motion or it is ready for hearing or motion
Ready
stage.
for hearing, my lord.
Ready for hearing. You just write on the top of it, hearing.
Hearing.
You have given notice to the learned advocate for the state?
Yes, my lord.
Okay. Write it hearing at any hearing list. Yes.
To submit a report, but the matter is not taken up, and illegal construction is going on by splitting up the water board.
Returnable motion issue. Returnable motion. You have given notice to the state. Madam, why aren't you understanding that order passed by a court, it will appear under to be mentioned to be corrected by that court. This court has no jurisdiction to change the order. Move before the court. This court has no determination or jurisdiction to correct that order. If there is any typographical mistake, it will be corrected by the order court which passed the order. I cannot. হ্যাঁ কিসের আপগ্রেডেশনে বললো তাহলে নোটিশ দিতে হবে তো
I have already served the notice, my lord.
নোটিশটা দিতে হবে annex the notice or bring the notice tomorrow you mentioned tomorrow day after which is feasible for you.
I am giving to the court officer, my lord.
No, what you do is annex that and then move and list it. Chal.
One matter for inclusion in the list. Unlisted motion.
Non-prosecution, give a notice to the other side. Give.
Motion 2024 unlisted.
New motion.
New motion to new.
New motion to.
Item number 33 of your lordship today's list, that this matter has been listed at my instance, but in this matter, my lord, the service has not yet been completed.
When the matter will be taken up, you respond.
My lord, may I permit one matter? It is a returnable motion. The petitioner is a senior citizen, and the grievance of the petitioner is a illegal.
Appearing in the list.
Yes, monthly list.
Monthly item number.
Item number 239.
239. Flap দিলে ভালো হতো। কত বলো 239
239.
Cipra.
Yes.
What has happened?
My lord, the grievance of the petitioner is that the illegal constructions as done by the private respondent and the feeling of the illegal feeling of the pond. That is the grievances of the petitioner.
We'll see afterwards. এটা এখন দরকার নেই returnable motion. Please do.
Item number 1.
Well, that the Haldia development.
Mujumdar has completed.
We have completed. Lordship, in fact, the respondent started also. For her.
Mr. Kollol Basu.
My lord, I apologize, but Mr. Kollol Basu is appearing in the Haldia Development Authority. He was right here, my lord, but a matter has been taken up in court 24. He's on his legs in court 24, my lord. He's praying for a short passover, my lord, if it is possible.
এটা একটা ডেট দেখে রাখো হিয়ারিং এর কবে আসছে
Yeah, we want as early as possible.
2008
Quite some time.
20th February next week হিয়ারিং এর দিয়ে দাও এটা তো অ্যাসাইন ম্যাটার পাঠাতে একটা লিস্ট করো This matter is appearing under the heading to be mentioned. With the consent of the parties, list this matter on 20th February 20. 20th February 2025. under the heading Group 1 Part Heard. Not required because part heard matter I will take it up as soon as the time permits because they are returnable motion, hearing, and then it will be listed. Let it come up on 20th. Let's see.
Grateful, my lord. Grateful.
Yes.
Item number 2.
But my application, your lordship, the application is coming for the first time, your lordship. For first time, your lordship. Lordship is contempt application. Lordship was passed order on 4th April 2024, your lordship. For comply for direction upon the land manager, your lordship. But since the order was communicated to them, your lordship, but no step has been taken till date. Lordship.
Who is for the state? Mr. Chandicharan, they appeared for the state.
After this order has been passed by your lordship, we have communicated on 9th April 2024, your lordship, page 95 of my application.
Response number 3.
Yes, your lordship. Now the content.
What was the direction?
My lord.
That you consider dispose of it. This has not been disposed of.
But it has been disposed of by your lordship, my lord. There is direction up.
No, the representation of the petition has not been
Not
disposed.
taken up yet, not yet, your lordship. There is no response from the end of the authority.
Achha.
The alleged contempt is, lordship.
Give a notice to Mr. Chandicharan De, who appeared for learned AGP, who appeared for the state.
My lord. Direction passed upon the authority for.
It is submitted by Mr. So-and-so learned advocate for the petitioner. Submits that respondent number 3. Sorry, by order dated 4th April 2024, passed in WPA 2606 of 2023. The respondent number 3, Land Manager, Urban Development Department and Municipal Affairs, Bidhan Nagar, was directed to consider and dispose of the representation of the petitioner dated 7 January 2023 within a period of 6 weeks from date of communication of the order. However, in spite of the order of this court being communicated,
On 9th April, your lordship.
the representation has not yet been disposed of. Learned advocate for the petitioner. In the aforesaid backdrop, learned advocate for the petitioner is directed to serve notice upon learned advocate for the state list this matter on next weekend, 21st.
One direction may be passed to lordship that the alleged contemptor, right, service upon the made upon the alleged contemptor also, your lordship. The alleged contemptor is, your lordship, page 7 of my application, your lordship. Rajiv Mondol, he is the person who is supposed
No,
to.
what you do is you serve upon the state. Let me find out what is the position, whether they have taken any steps. Thereafter, the notice will be issued.
Lordship.
First, Mr. Chandicharan, they let him come and apprise this court.
Lordship. Grateful, lordship.
Item number 3.
My contempt application, lordship, first time appearing. The lordship was pleased to pass on 14th of December 2022, lordship. We have communicated within time, lordship. It is at page number 25 representation on 30th of April 2022. There was a direction to dispose of the representation.
No.
By your lordship's order.
Give notice to the state. Same order, huh? At a provision, this contempt application arises out of an order dated. Mr. Mata is appearing in this case?
No.
Oh. No. Arises out of order dated 4th April 20. Similarly, a contempt application arises out of order dated passed in WPA such and such. Mr. and Learned advocate for the petitioner submits that by order dated 14 September 2023, who was directed? The District Magistrate Murshidabad.
Response number 3.
Response number 3. Executive engineer. By order dated 14 September 2023, respond number 3, executive engineer was directed to consider and dispose of the representation of the petitioner dated 14 December 2022 within a period of 2 months from date of communication of the order. You have communicated the order? The order of this court was duly communicated to respond number 3. However, till date, no steps has been taken. Learned advocate, in the aforesaid backdrop, learned advocate for the petitioner is directed to serve notice upon learned advocate for the state. 21st. এটাও 21 তারিখ না?
Item number 4.
This is my application. The Lordship granted leave yesterday, considering the urgency. This matter relates to tender. I participated in the tender process.
Affidavit of service.
My lord, affidavit of service. State is representing the panchayat has been served through email.
Yes.
There are two tender notice. First is at page 11. In tender number 11, I participated for serial number 5. Construction of CC road from Biren Mandal house to Tapan Mandal house. And another tender notice at page 16. In tender number 12, I participated in selection the serial number 15. Installation of water ATU at Sansad 3. My lord, I having the credential and all other documents, I uploaded the documents to the tendering authority. It was evaluated. Page 22.
Yes.
Serial number 5, Tanvi Enterprise.
Page 20.
22, sorry, Mal. Serial number 5, Tanvi Enterprise. Everything is yes, but remark litigation history. On that ground, my lord, my selection was cancelled. And without a specification of any litigation history or anything, this was done. And in the tender notice, it was specified that the technical bid will be opened and that will be notified later. But surprisingly, after getting the notice of this writ petition yesterday in the evening, the financial bid has been opened without any notification. In this way, the government and money is being siphoned out. Favorable person are being granted the tender.
So your application has been rejected on the ground of litigation history.
Yes, yes. I have not, my financial bid was not opened. I have not been called upon.
Oh, yeah. In others, no, 15.
Yes.
You say you participate in 16?
No, 15. Two notification. In first notification, I participated in serial number 5.
15.
Page 11.
And 17. Page 17, serial 15.
Serial 15, yes. These two serials I participated.
In both the
cases,
financial bid has been opened.
Well, 22 and 23, the technical evaluation, both the cases, well, litigation history.
Yes.
But 15, there is no litigation history.
Both.
What
Abstract
litigation history?
proposition.
Malad, kindly come paragraph 4 of the writ petition. He himself admitted and affirmed on oath he has litigation.
So,
Paragraph 4. there is litigation history of the concerned firm. It is on oath.
Yes.
To his knowledge. Then nothing is to my lord. And
Now
not only that, only one paragraph, but also in the another paragraph also this thing has been done.
No is omitted. Now, your lordship, kindly come to
No,
page
my lord,
24.
Now the petition cannot be maintained.
Your
If
lordship,
he want
kindly
to
come
amend
to
the
page
petition,
24. On.
whatever may be, this is the statement in affirm on oath. So if he want to amend his petition, he has to either amendment or he has to
Withdraw.
withdraw this
Withdraw
petition
and
and
file.
file.
Withdraw and file.
Withdraw and
That's
file.
true. Now, your lordship, kindly come to page 24.
Page
24. Writ petition has been drafted by me. There may be some wrong. Your lordship, kindly come to page 24. আমার বিনীত নিবেদন এই যে উপরোক্ত রেফারেন্স নাম্বারগুলি টেন্ডার অংশগ্রহণ করেছিলাম আমার পেপারে সমস্ত কিছু সঠিক থাকা সত্ত্বেও লিটিগেশন হিস্ট্রি কারণ দেখে টেন্ডার থেকে বাদ দিয়েছে কিন্তু আমার নামে কোনো লিটিগেশন হিস্ট্রি নেই দিস ওয়াজ দ্য মাইলড ভার্সন অফ দ্য পিটিশনার হিমসেলফ মাইলড দেয়ার মে বি এ রং মাইলড আই হ্যাভ কমিটেড এ রং that no is omitted mailed that is technical error and typographical error.
This is the main
But the
error.
fact remains that how could they, on the ground of his litigation history, a tenderer can be ousted. Even if there be any litigation history,
Yes,
can
that
they
is
do
the
so?
that is
Can
the
they
terms
do
and
so?
Terms and condition of the tender.
Right.
That if there is any litigation, he has to inform it. Kindly come, my lord, the page 13. Page 13, clause 13.
Informs in any litigation occurred in the last 5 years in between any court.
Information regarding any litigation or arbitration during the last 5 years in which the bidder is involved. If there is any litigation, he admitted his litigation and it is to be informed. That is the terms and condition of the mallet tender. And the next also 17 also the same.
Therefore, they have found any litigation in my lord in my tender papers. Let them produce that. If there be any litigation, I will be out of
Litigation
court.
is not maintainable.
If there be any litigation against me,
In view of the
my lord, they-
admission affirm on oath, this petition is not maintainable. My lord, I am
this is-
relying upon the 3 judges bench of the Supreme Court, Bharat Singh case. My lord, kindly see only go through the paragraph 13.
আছে, আছে দাদা, আমিও জানি।
It can,
These are absolute technicality.
or he has to amend this petition by way of amending application that I have committed mistake. That is
Yes, it
oath
can be-
versus oath.
This can be done.
Yes, then
It
let-
can
let
be
it
done.
before
But
Take out
this-
an application then.
My lord,
I shall.
withdraw.
But can withdraw? Application করবো আমি।
Or file an application for amendment.
Withdraw. This is not
Yes.
done. My lord, tomorrow it will be filed. But insofar as the tender, my lord, financial bid last night it was open. It was the apprehension that it will be
It is
done.
not maintainable.
I'll correct the averments because
Yes.
that is the fulcrum of the entire.
Yes.
Huh? Mr. Robiul Islam, learned advocate appearing for the petitioner, submits that the typographical error has crept
In
into,
ground, my lord, I have correctly stated. Ground
has
3.
crept into paragraph number 4 of the writ petition.
4 and 5. 4 and 5.
4 and 5 of the writ petition. He seeks to take appropriate steps for correction of the same. Will it by way of an application or supplementary affidavit? Amendment application.
Application.
Amendment petition.
That is application.
When can you file this?
Tomorrow.
Tomorrow you'll file. Is this
Client
matter
is here
Friday?
in Kolkata.
Friday.
Friday is holiday, my lord. My lord,
No holiday. Friday can holiday. High Court can holiday.
High Court holiday দেয়নি? Declared. It will be declared, my lord. That was the proposition in the notification that the
for what?
No.
Shabe Barat.
Shabe is 13th.
Idul Zoha and Shabe Barat. That will be notified by the High Court in due course.
Okay, if it is comes then on Monday,
Till now.
Monday.
let it be fixed on Friday.
2 PM it can be done.
Tomorrow this bench will not be there. After Friday, keep it on Friday. affidavit of service, take it back. আচ্ছা ওটা নিয়ে নিন রেকর্ডটা
In the
ওপরে দিয়ে দিন
meantime, it should be kept on record. In the
মন্টু বাবু
meantime, the Pradhan
affidavit
is
of
the
service filed on behalf of the petitioner is taken on record, yes?
The Pradhan is the main respondent. He must serve him
He has been.
by email, but
Email is a good service.
good service. I am not.
First let the writ petition be corrected and made in form. Thereafter we
that
see the service.
that service be affected upon the Pradhan.
আমি আবার
Item number 5.
এই প্রীতম বাবু
Mrs. Juma Chakraborty is appearing for state, your lordship. She is appearing online.
But I am appealing for state.
For the petition.
I am appealing for state, my lord.
Okay.
I am filing the affidavit of service. This is Millard challenging Millard my claim for compassionate appointment. It was rejected on the ground that the application was made belatedly. And I'll take your lordships to the documents to show that it was not that it was not made belatedly, and second, Millard, the rejection ground is contrary to the Millard the regulations of guiding the compassionate appointment. And if your lordships kindly takes up page 15 first, Millard, that is the death certificate of my father, and my father passed away on September 29, 2016, and this date is important. And thereafter, Millard, at Millard page 23, well, I made an application in plain paper. It is in Bengali.
You are the son.
I'm the son.
Son and who is the other petitioner?
Son and daughter, Millard, we are seeking in respect of the son only because Millard, two persons cannot be appointed, but the other person was also dependent on the income of the father.
So who applied for compassion?
The son applied.
So how come petition number 2 is a necessary party?
In the pro forma, I have to give a no objection from whoever.
But she has given no objection.
She has given no objection. That is why I have made party. Ultimately, the son will, if the petition is allowed, the son will be.
Okay.
And if your lordship
16 is the death certificate of mother.
Yes, both the mother and father passed away, but we are concerned with the death certificate of the father at page 15.
Predeceased. Mother predeceased father.
Mother predeceased father.
Which page?
Page 15 is the death certificate. Then your lordships kindly takes up the first application in plain paper at page 23.
Here.
And I was not aware of the requirement under law that I had to make up application in pro forma. Nevertheless, upon being informed, I make the pro forma application, which is immediately at the next page at page 24. And, from this document, if your lordships takes up page 29, I had to give a no objection also. This document is dated 22nd of August 2019. I made this pro forma application in 2019. Which is roughly 3 years after the date of my father, from 2016.
Meron, where is the date?
The date your lordships will find at page 20.
1st December 2019, my lord.
1st December.
The application pro forma was submitted. My lord, they have applied delay. They didn't fulfill the norms in which they have to apply, my lord. That is the main question.
So what is the date of this application? In which page?
Actually, 1st December 2019.
Where is the date? In which page, madam?
My lord, I will request my junior to hand over the report, wherefrom your lordship can understand, as per our record, what is the submission date of the application. My lord, kindly come to the report, first page of report. 4th paragraph, my lord.
1st
5th
December.
paragraph. 1st December 2019.
After date of issue of PPO.
By the applicant to the office of the BDO, Murshidabad Jiaganj block. The letter had forwarded it along with necessary reports and documents to the office of DPRDO on 20th February 2020.
Yes.
And from where the application was forwarded to the office
Yeah,
of the
petition.
Commissioner Panchayat, West Bengal on
Madam, we
4th.
will hear you.
Yes,
Let them submit.
That your Lordship
my
has,
lord.
has got
My
that. But I'm just referring once again, lad. On 12th December, 12th October 2015, my mother died. On 29th September 2016, my father died. Now, my lord, father was the employee. My lord, on his death, my lord, I made an application at page 23, my lord, on 3rd October 2016 in plain paper. Amlat, this is in plain paper. Amlat, I have specifically pleaded Amlat, at paragraph 6 of my writ petition that in the
Yes.
that after this application, only in the month of December 2019, the BDO informed me to submit a pro forma that was handed over to me.
Inform me verbally.
Verbally. No formal communication.
Because they were not aware about the submission rules.
Amlat, immediately I submitted a pro forma. My application was there. In pro forma, I have submitted later on. So my intention and my prayer was already there on and from 2016. Amlat, page 31, lad. Kindly see, lad. They are considering me as belated case, lad.
What is the time frame? Is there any time frame to apply for?
According to me,
6
lad,
months.
according to me, lad, in terms of the amendment that was brought in, lad, 5 years in my case.
So the rule?
Yes. This is the relevant part. 10 AA. Before that, I'm just referring this document once, only once.
31.
31. As per approval of the Commissioner of Panchayat and Rural Development West Bengal, the proposal with the necessary documents for considering appointment on compassionate ground in respect of the belated application. So, they are considering my application as belated application.
Okay.
Because at the relevant point of time in 2016, I was not eligible due to my age. I was a minor. Now, that's why I have referred this amendment provision, which refers, which says 5 years. Now, what are the records they have considered? There has been given letter, pro forma application in the box. Then 3 months committee report, NOC of the dependents, undertaking, attested copy of the death certificate, identity proof. All these were considered as belated case. Belated case. That's why they have taken this report also. Now, clause 10 small AA in the notification, the second page. Now, that's just now I have handed over. Yes. From the bottom, second box.
Belated requests.
Yes. That they have considered as belated request. In exceptional cases, such as death during action where none in the family is eligible, etc. None was eligible since my age was below 18. Departments can consider request for compassionate appointment even where death or retirement on medical ground of the government servant took place up to 5 years ago. While considering such belated request, the 3-member screening inquiry committee should, however, keep in view that concept of compassion appointment is largely related to the need for immediate assistance to the family of the government servant in order to relieve it from economic distress. Very fact that the family has been able to manage somehow all these years should normally be taken as adequate proof, and the family had some dependable means of sustenance. Therefore, examination of such cases could call for a great deal of circumspection at all levels. Dependent member must invariably attain the minimum age of appointment at the time of consideration. Similar at the time of consideration, now I have attained 18 years.
When?
Now, as a belated case, as admittedly from the record, I can demonstrate that they can consider up to 5 years, and that's the reason the BDO allow me to submit that pro forma. In fact, they have proceeded further, and the committee report was already there. This committee is supposed to decide whether
5 years means suppose a person at the time of death of the employee, he is minor. But he attains majority after 5 years. Will the application be considered after 5 years?
On the date of consideration,
No, as per rule, up to 5 years there is relaxation.
Yes.
It cannot be considered a belated case. It has to be accepted. Up to 5 years there is. Now, since the employee dies and the minor is to attend after the expiry of 5 years, will the case of the minor be considered after expiry of 5 years?
Even last line.
Have you understood the question?
Yes. Even after 5 years.
Yes.
The dependent member must invariably attain the minimum age of appointment at the time of consideration. So, 2023 is a consideration age.
No,
I'm again reading that clause only.
No, in the year 2016, what was the age of the petition number 1?
That must be 2016 have passed HS. So
then he has attained majority.
No. Yes. Well, after passing it is attained majority.
So there cannot be any case that since he did not attain majority, he could not apply. What is the Madhyamik certificate? What is the date of birth?
Rabiul
Sani.
Rabiul Sani. Date of birth 17th August 1997.
17th August 1997. Oh, he was more than 18 years in March 2016.
In March 2016, yes.
He was more than 18 years.
Attains majority.
So minimum age is 18 years for employment in a government. So he attained 18 years.
Attained 18 years, yes.
So there cannot be any ground that since he did not attain majority, he could not apply. This ground goes.
This ground goes, yes.
Now 5 years. You have 5 years. As per the rule, you say that 5 years, up to 5 years, this can be considered. Okay.
But rather, I'll submit these rules or whatever the notifications they have issued are the guideline for considering it. These are regulatory. The objective is that the employee dies. There is some sustenance is required for survival by the rest family members. That is the objective. Now, in my case, I can demonstrate from the records that my mother died when I was a minor in 2015. Immediately in the next year, father dies. There was nobody to look after at the age of my 18 years. The committee has gone into it. that record I have shown, my lord, that committee has gone into it.
What is the order passed? Only because it is
Only because it is, my lord, belated.
Where is that order?
My lord, that is at page 32. My lord. My lord, today, my lord, at the time of motion stage, my lord, if you are so considers, my lord, I'll be submitting that since they have already there exists already a committee report which has considered my difficulties. Now, my lord, if that report be placed before your lordship, and if your lordship satisfies that the yes report is there, if the report is in negative, I have to in any event challenge that. They have rejected my claim on technical ground.
Okay.
Let that report be placed before your lordships. If your lordship satisfies, then we can proceed
Pradhan,
further.
who has passed this order?
The Assistant Secretary, Government of West Bengal, Panchayat and Rural Development Department.
All have been served. State is represented.
Yes, state is represented. They are the answering respondent.
Who is the pro forma respondent here?
Pro forma is my family member, my younger brother.
Younger.
He is supporting our cause. Most certainly.
What is the inquiry report?
A 3-man committee report, that has been referred in page 31. Page 31, second clause, 3-man committee report.
Okay. Yes, madam.
My lord, as per GO number 251 EMP dated 3rd December 2013, they're supposed to apply the application in the specific format within 6 months, my lord. And they didn't apply that. And that's why while we have inquired to apply that application in the specific date, that time they have applied. But that time when they have applied that thing, my lord, that formalities has been completed much more delayed after they completing the entire formalities while we have inquired. And that's why we have sent all the documents to the committee. Now it has to be considered, my lord. Because it has resubmitted by office of the BDO Murshidabad Jiaganj block to the office of the DPRDO on 22nd February 2022, and then once again on 7th June 2022. Then it was moved through the same proper channel to the sanctioning authority, my lord, Assistant Secretary of the Government of West Bengal, Panchayat and Rural Development Department, my lord. And from where it was rejected on the ground that late submission, my lord. Because that ground has not been considered by that committee, my lord.
You file the three-man committee report. You produce
My
a
lord.
copy of that. And what are the orders passed in the proceedings? Since they say that on 3rd October 2016, they first made a application in a
But
blank.
it is on the plain paper.
It is
Plain paper. Plain paper. They didn't fulfill that formalities on such date, my lord.
No, but also this was not.
But we tried to help that petitioner that as
produced
they
that
are the dependent, my lord.
See,
But it has been
when an
rejected, my lord.
application has been filed. If they are not informed that this pro forma has to be filled up within a period of 6 months, so here's a case, you produce that. What has been reported by the three-man committee, let us see.
My lord.
This writ petition has been filed seeking for setting aside of letter dated 17th April 2023 of Assistant Secretary to the Government of West Bengal, Panchayat and Rural Development Department. Respondent number? Respondent number party name.
2 and 3. Rather 2.
2 is wrong. 2 is wrong. The designation is wrong. 17th April 2023 is passed by Assistant Secretary, not Additional Secretary.
The additional secretary, they made party additional secretary.
It will be assistant.
So it's the wrong part.
Can you grant me liberty so that I can correct?
Assistant
After
secretary.
closing, affidavit of service filed on behalf of the petitioner is
Additional
taken on
secretary.
record. On the prayer of learned advocate for the petitioner, liberty is granted to correct the designation of respondent number 2. হ্যাঁ এবার চলে আসুন রেসপন্ড নাম্বার 2 অ্যাসিস্ট্যান্ট সেক্রেটারি বলে দেবো না হ্যাঁ রেসপন্ড নাম্বার 2 যেটা ফর্মটা বলছেন দিস পিটিশন ইজ ফাইলড হ্যাঁ মিস্টার সো এন্ড সো প্যারা মিস্টার সো এন্ড সো লার্নেড অ্যাডভোকেট ও না সরি ওটা ভুল বললাম রিজেক্টিং দি পিটিশনার্স নাম্বার 1's অ্যাপ্লিকেশন ওটা কন্টিনিউ করুন ওটা যেটা বললাম না রেসপন্ড নাম্বার 2 রিজেক্টিং দি অ্যাপ্লিকেশন অফ পিটিশন নাম্বার 1 for appointment on compassionate ground. Mr. Swanso, learned advocate appearing for the petitioners, submits that the application of petition number 1 for appointment on compassionate ground has been rejected solely on the ground of it being belated one. Referring to a Gazette notification dated 1st March 2016, he submits that the application ought to have been considered by the authorities since the same has been filed within a period of 5 years. He also indicates that prior to filing the application in proper format, the petitioner submitted an application in a plain paper on 3rd October 2016 upon death of his father on 29 September 2016. Since the petitioner was not informed to submit application on proper format, he could only submit the application in the month of December 2019. He seeks for a direction upon the state to produce the 3-man committee report which has considered the prayer of the petitioner for condonation of delay. In view of such submissions, state respondent is directed to file a report annexing all the documents will not be necessary as per 31.
They can, this will be convenient for the court also to decide the matter. If they produce the entire records as.
Madam, you produce all the documents which were considered by the authority.
My lord, I will. My lord.
File report annexing the documents appearing at page 31 within bracket annexure P7 of the writ petition. Positively on the returnable date. Is this matter returnable? It motion chole jabe. Huh? Huh. Huh. 2 weeks ago. 27th.
Grateful, my lord.
এটা কে দিয়েছে এটা কিন্তু ফর্ম অফ রিপোর্ট দিয়ে দিতে বল এটা এখন রিটার্ন করে দিচ্ছে
I believe this matter will appear fairly at the top level.
Let it appear in the returnable receipt.
Returnable motion.
Next.
Item number 6.
For the petition.
Okay.
Let
This case, the petitioner.
Affidavit is served.
My lord. The petitioner was initially entrusted with the job of my lord water project to my lord operate and function. My lord, kindly comes to my page 12 first.
Who is appearing for Pradhan? Pradhan delivered.
I have served everybody. Pradhan is served. Pradhan does not appear.
Remains
Right.
So state has to.
State normally, my lord, because the video is there. So through video or SDU in case of demolition.
Page 12.
Not to deprave further expense.
Page 12.
Page 16. Page 16.
Yes.
Page 12. Malad, that is the point. Malad, 16. Well, thereafter, what happened? Malad, I have given my own land. Malad, the pump was also installed at my own land. But thereafter, Malad, a padlock was given by the Pradhan and his associates. Malad, I have made representations. Even I have not been given access to Malad operate such project.
But it appears.
I have made several representations even after that. They kept simply mum over that issue.
That
it is being operated by their desired
small
candidate.
block of the land they have gifted to the minor authority, I mean the Contempt, for the purpose of installation of a water pump for distribution of the clean water to the residents of the ground, the village. And my lord, on a condition that after the pump is installed, the landowner who gifted the same, he would be the operator of the pump. Now, my lord, it appears further that installation complete, but the operation has not yet been started. For any reason that is not disclosed or may not be their knowledge, but it is still under lock and key, that compound. Now he made a representation. It appeared that the same contention in most of the representation, but representation to diverse authority. Even it appears, my lord, at page number 14 to the Block Development Authority, video Kalna 1. One of my humble submission that this matter can be disposed of either directing the Pradhan Contempt or to the matter the video Kalna to look into the matter and dispose of the representation. If on the basis of that represent, I think that if there is any deed of gift at all, if there is any condition the deed of gift, then let that be considered.
Page 12 is absolutely clear.
I am not on that.
Because
I
he
am
has been handed
neither-
over. That is an official document.
I am here neither accepting nor denying. Whatever the facts are there, facts are there. But since those representations are still pending, let the authority, either of the authority, let it be considered.
And it is the specific case of the petitioner that the Pradhan is not only giving access to me, he is hiring some other persons on their own desired candidate, and they are functioning this project. But at my cost,
So he says
at
that
my
it is not
electricity.
operational.
It is operational.
It is on the
Because
basis
from the
of his apartments on the petition.
because on the
it is under
representation.
Oh.
On the
Mala-
basis of his apartment.
Under the lock and key, under the custody of the Pradhan.
Installation complete, but the operation has not yet been started.
Under the custody of the Pradhan, it is
So,
not
Mala,
made
without
accessible
going into
to the
those
petitioner.
Those questions,
Mala, I have
if
mentioned
has
the
been
name.
right arising out of that deed of gift, then Mala, let it be considered.
But no question because on page 12, well, it is very much clear that I have been handed over the project, entrusted with the project. There cannot be any denial part. Well, the petitioner further asserts that there is a person. Well, I have named that person in the representation. He is operating that.
May I do? Otherwise, there would be an my lord, both verses, so then I have to file an affidavit whether Pradhan have had any right to issue this letter.
Yes, I am also not
So
contradicting
I
that.
am not going into those questions. Whatever be the facts are there, let those facts be there. Only thing, he made representation, very good. At the first instance, said representation be
And let it be considered.
either by video or by the, I think video should be the my lord, the much more competent person.
Then which representation will you consider?
Page number 14 is my lord, address to
18.
page 14 is right. না, না, আগে। ও, তাহলে কোনটা হবে?
18, page 18.
18, very
Page 18. 29/7/2022.
Okay. This writ petition is filed seeking direction upon the Panchayat authority and their men and agents to take steps towards considering the representation of the petitioner.
Page 18. And to take steps in terms of letter dated 31st May 2022. The petitioner's case in brief is that the petitioner handed over land for setting up of pump house for pumping water supply scheme at Muslimabad, Purbo Pada, Mauja Briddhopada under Adghoria Simlan Gram Panchayat. Pide NIET, এটা ছোট, number Kalna 1 PS/06/2018-19 dated 18 December 2018. To the Panchayat authority. You have handed over to Panchayat authority. Yes.
Panchayat authority. Although later dated 31st May 2022 was issued to the petitioner for operating such water supply, but the pumping room was not made accessible to the petitioner. The petitioner made several representations before the local Pradhan, local Gram Panchayat, the Pradhan of local Gram Panchayat, as well as to the BDO Kalna 1, Purbo Bardhaman. Since no steps has been taken, the petitioner is constrained to file the present writ petition. Mr. Swenso, learned advocate for the petitioner, submits that the representation dated direction be issued to who is BDO is respond number? BDO Kalna.
BDO 7. Joint video.
BDO has not been made a party.
7.
Then this is joint block.
Opor দিয়ে দিন তাহলে leave granted to add block development officer Kalna 1 Kalna Purbo Bardhaman to add বললাম না ওমু as party added respondent. On the prayer on the prayer of learned advocate for the petitioner, leave granted. চলে আসো. Submits that direction be issued upon the added respondent number 10, BDO Kalna 1, Kalna Purva Bardhaman, to consider the representation of the petitioner dated 29 July 2022. Mr. Spencer, learned advocate, Parakore, appearing on behalf of the state respondents, also submits that the representation of the petitioner be relegated to the BDO for consideration and disposal. In view of such submissions, advanced by the respected learned advocates, Omuk advisement directed to consider and dispose of the representation of the petitioner dated 29 July 2022 by a reasoned order after giving opportunity of hearing to all the interested parties, including the petitioner, within a period of 2 and the Panchayat Pradhan within a period of 4 weeks. Then make it 2 months within a period of 8 weeks from date of communication of this order.
At the time of communication of my lord's order, a copy of this representation be also annexed there.
Petitioner, yes. Petitioner is directed to communicate this order to the added respondent number 10, a block development officer, along with a copy of the representation. It is made clear that this court has not gone into the merits of this application. Since no affidavit has been called for, the allegations made in the writ petition is deemed to be not admitted. With the aforesaid observation, the writ petition being number 6178 of 2024 stands disposed of. All connected applications, interim order if any. Reasoned order be reasoned order be communicated to the petitioner. So the Prudhanti is question.
Item number 7. Lordship, most humbly I beg to appear on behalf of the petitioner. Most humbly I beg to appear on behalf of the petitioner.
I'm straight, yes.
You are fine.
Lordship, the petitioners, my lord, are claiming that they are the owner of the plot, my lord. The area, my lord, the private respondents, my lord, are also claiming that some portion belongs to them as well because there is no partition. So they are also.
No, it is a joint property.
Lordship, a plot was there, RS Dag number 372 and 373, and from there 9 Chatak was the total area, my lord. From that it has transferred to the 4 sons. And I am the petitioner of one of the son, my lord.
You are the legal heir of one of the son.
Lordship.
So this is a joint property.
Lordship. And my lord, to that extent, my lord, I was also, I am claiming my ownership regarding 3 Chatak of land, my lord. And my lord, to that I was proceeding to make one construction, my lord. So they were making objection to that. So I have filed one title suit, my lord. And in the title suit, for order 39 rule 1-2, an order was passed, my lord, to maintain status quo. And then, my lord, they have also filed. They have also filed, my lord, 144 application so that they can proceed with the one kacha construction, my lord. To that, my lord, one order was passed, my lord. In that order, my lord, specifically it was stated that if they will make the construction, that will be strictly in compliance with the municipal rules, my lord. But they have made the construction, my lord. I have made. There was some, my lord, physical aggression as well. For that, my lord, I have made one complaint, my lord, to the concerned police station. One writ application is also pending before this honorable court regarding under the determination of police inaction. But that is not regarding this, my lord. My only contention in this application is that, my lord, they have made one construction, my lord. I am alleging that that is completely without any necessary permission, my lord. To that, I have made one representation to the Gram Panchayat and SDO, my lord. They have not considered. Pradhan, my lord, I have made. I have also made to SDO, my lord. So, my lord, my only contention is, my lord, let it be, if your lordship may allow, let it be considered, my lord. That is on the merits, my lord.
No allegation has been made relating to unauthorized construction. Pradhan, no representation has been made to the Pradhan, who is the appropriate authority. Here the representation is page 34, addressed to the SDO, District Magistrate, ADM, Commissioner of Police, Inspector in charge. And here all the environment is relating to the encroachment and otherwise, not illegal construction. And allegation is also that the kacha construction, unless it is brick built, no sanction is necessary. That is under the Panchayat. But totally misconceived petition. And
Where is the allegation that they are carrying on unauthorized construction of
his allegation
temporary?
he said in the petition some paragraph that kacha construction, not brick
Blood.
built.
And blood, in addition to my candidate senior friend, blood, I am drawing the attention of your lordship, page 33. Blood, the photograph my landed friend has annexed. In the photographs, from the photograph itself, it will be revealed that all these are the blood thin set construction. Blood, for which no blood the sanction is required. My landed senior friend correctly submitted.
And my lord, if you lordship, my lord, we can go to the my lord, representation that not a single word or relating to the unauthorized construction and no permission.
And moreover,
My lord, page, my lord, to that, my lord,
boundaries.
my lord, to that, my lord, page 36, I have written, my lord, in the second paragraph,
Without
my lord.
information approval form.
Second paragraph, I have specifically mentioned, my lord, that after
But page 30, kindly page 30, Lord, that is the representation before the Commissioner of Police.
No.
Page 38.
my lord,
Page 30, 30. Blood, the middle portion, there the encroachment. Encroachment, the jurisdiction of the civil court, blood. Because it
And
requires the
already
evidence.
statutory there.
And
Well-
page 34, blood, the kindly see the district magistrate, ADMLR, Commissioner of Police, Inspector in charge, and the act of SDO. The appropriate authority is the Pradhan, which correctly submitted by my landed senior friend.
And there is not a single word in the representation that it is unauthorized construction and without any sanction. Not a single word. And it's totally misconceived.
His writ petition has been filed.
lordship, to that, my lord,
Affidavit of service.
lordship, I have served. My lord, to that, my lord, I am,
The affidavit.
lordship, to that, my lord, I'm,
This writ petition has been filed.
my lord, to that, my lord, kindly allow me to say something, my lord. Only, my lord, kindly allow me. My lord, regarding that construction, my lord, my lord, to that construction, my lord, to a title suit has been filed for encroachment, my lord. For encroachment, my lord, I'm understanding, my lord, read code will not allow the same, my lord. For encroachment, I have to move to the title suit. I have moved to the title suit, and it will be decided according to the merits, my lord. But my only contention is that, my lord, without any permission, my lord, any structure can be built, and without that structure, if there is no necessary permission is required. To that, if, my lord, to that extent, my lord, if it is falling from your lordship that there is nothing mentioned in my representation, my lord, I have mentioned that it is an illegal construction. I can show to your lordship if your lordship allows. But if it is not mentioned, my lord, kindly give me liberty, my lord, so that I can make representation to the Pradhan, to that. Lord, kindly give me liberty to that, my lord.
Not in this writ petition.
In this writ petition, my lord, I have,
If you make representation, that is up to you.
my lord, I have,
You face problem, but you cannot bring every fact
Lordship.
within a particular
Lordship.
writ petition. Since in the writ petition itself you say that this is a kacha construction.
lordship. My lord, only one thing, my lord. If liberties,
Hard.
lordship, only one
Well,
thing.
the
If liberties
this
given, my lord,
affidavit of service
kindly,
filed on behalf of the petition is taken on record. This writ petition has been filed for seeking direction upon the respondents, their men and agents, to take strict action against the unauthorized construction of the private respondent undertaken without any permission from the concerned authorities, and also to consider the representation dated 4th March 2024. The petitioner's case is that the petitioner is one of the co-sharer.
lordship.
Co-sharer
My lord, I'm alleging that I am the owner of 3 shatak
is
of land.
one of the
Well,
petitioner
I am
is
the
the
owner.
of a piece and parcel of land
Lordship.
measuring 3 shatok at Mouja Atishara, jail number 17, Reksa capital X, comma Touji 2010 under RS Panchayat, it is there, no?
Lordship, section
Panchayat it is?
23 of the Act, my lord. Kindly consider
Under section
specifically.
under RS Kotian number 105, LR Kotian number 851, RS Dag number 373, LR Dag number 409. The private respondent, it is alleged that the private respondents are making unauthorized construction over which land? Over your land.
Lordship.
Over the land of the petitioner. Illegally without any permission.
Paragraph 14, my lord,
Representation.
kindly comes once, my lord, paragraph 14. My lord, sorry, I do not want to disturb. My lord, paragraph 14 only, my lord. Section
14.
23 of my writ application, my lord. It specifically says that without any structure cannot be constructed, my lord, without the permission, my lord. Kindly comes to section 23 once.
Representation has to be made to
So that representation I'm taking liberty from lordship, so that it can be considered. Otherwise, it will be pending for individual. So I'm taking.
That the private restaurants are making unauthorized construction over the land of petitioner illegal without any permission.
Without any permission. The petitioner made representation before the respondent numbers
Lordship, 3, 2 and 3.
Respondent number
Those they are not party, my lord. Even page 30 and 30.
3.
No, my lord.
Three.
Page, no, my lord.
Wait,
there, my lord.
let me find out. 2, 3.
Lordship.
2, 3 is there.
Comma.
Only 2 and 3 there.
ADM
No, it is
LR.
not made party.
No, I'm giving the name now.
Well,
Respondent number 2 and 3, comma ADM LR O. Commissioner Police is a party.
Lordship.
Commissioner
no,
of Police,
because-
Barakpur Police Commissionerate and Inspector in charge, Sivdagpur Police Station. একটু বইটা দাও না পঞ্চায়েত
Section 23. my lord.
না এই মোটা বইটা দাও মোটা বই।
Well, it is there. This whole book is there. 23.
No, you indicated rule 19.
Rule 19, that is brick bill.
Lordship. Any structure is
That is brick bill.
obstructed.
Rule 19.
Section 20.
But it is asbestos said.
Lordship.
So the permission will not be required in case.
If it is brick built, permission is required.
But he says it is kacha construction.
He said kacha structure, so there is no question of. If it is brick built,
Lordship.
brick
So
built,
this-
then it is my lord permission is there.
I can, my lord, submit representation to the Pradhan, my lord, if lordship grants that liberty, my lord, and it needs to be considered within time frame.
এটা ছিল সেদিনে কোট করলাম না রুল 19 টা
I have specifically mentioned, my lord.
which is that rule Mr. Mahathir 19
My lord, West Bengal Gram Panchayat,
exemption from permission here.
Gram Panchayat Administration Rule
The company
19.
shall be necessary for erection of thatched structure, tin shed or shed without brick built.
Without brick built. If it is brick built, my lord, then my permission is, and that he has to make representation to the Pradhan, whether it is sanctioned or non-sanctioned.
Whether respondent number 3 will not be considering that, my lord,
No.
I have made.
No,
Then
he
I'm
has
taking
no
liberty.
jurisdiction.
Then, my lord, sir. And then I'm taking liberty. My lord, then I'm taking liberty. I will be submitting within time frame if they can. I have not made party. It is my mistake, my lord. But in the representation, I will make a new representation.
Representation made before such and such, but that has not been considered, hence this writ petition. Mr. So and so, learned advocate, seeks for consideration of the representation made before the authorities, representations by the authorities. Mr. Mahata, Lalit Mohan Mahata, learned additional government pleader, submits that it is the case of the petitioner that the structure is kacha structure. And therefore, section 23 provides for
Any structure.
Sanction of a building plan, and thereafter, my lord, he can construct.
Structure.
Or if it is not without sanction, then it can be demolished.
So it does not say of kacha or pakka structure.
Pakka.
Pakka structure.
Brick built.
Submits that. And therefore, the application seeking for necessary direction for removal of unauthorized construction is misconceived one. Mr. So-and-so learned advocate, he seeks for dismissal of the writ petition. Mr. So-and-so learned advocate representing.
Paragraph 7 says kacha structure.
My lord, let there be an inspection, my lord. To that, my lord, if it is
No, no.
nature of construction, my lord, it will be demolished, and if it is not, then it will be stayed, my lord. I'm just beseeching your lordship for permission, my lord. If it is not made party, my lord, I'm accepting my mistake. If it is not made party, my lord.
Contempt.
স্যার ক্লায়েন্টের আমারও তো একটা রেসপন্সিবিলিটি আমি ছেড়ে দেবো স্যার আমাদের
দেবাংশু ওটাকে কোর্টে গিয়ে এইভাবে বলার চেষ্টা করতে হতো তোমার তুমি এখন কোনো আইডিয়া নেই
না শুধু রিপ্রেজেন্টেশন সব তো আমার ডিফারেন্ট কমপ্লেন
Submits that. Submits in the same fashion. Private respondent. Upon going through the writ petition as well as the representations made before the authorities as mentioned aforesaid, it is found that the admittedly the structure is a kacha structure. It is a tin structure.
Started construction of a kacha structure.
My lord, after that, my lord, whether there should be
Rule
there
19.
should be some inspection, my lord. Some inspection.
Rule 19 provides as hereunder. Since
Rule 19 is in another rule.
Since admittedly the structure is kacha structure.
Rule 19. Gam Panchayat Administration Rule 2004.
Therefore, the prayer made by the petitioner is misconceived one. Accordingly, next paragraph goes accordingly, the writ petition falls short of merit, hence writ petition stands dismissed.
Lord, without no inspection will be there, my lord. Let it there be inspection, my lord, or give me liberty, lordship, kindly, my lord, so that I can make research. Further, if they make
then I have to also express my opinion with regard to the civil suit pending.
Civil suit pending.
That I have not done.
And,
my lord, apart from civil suit,
it is a misconceived that you understand. First, you also submit that in title suit you have filed an application, and for encroachment also you have filed an application. I cannot give you liberty to correct what you have
my
not
lord,
done.
but that is, my lord, statutory
It is
obligation.
open to you. If you want to take steps,
My
go
lord,
ahead
but
with that.
only one liberty was if a lordship
No,
made
no,
it
no,
permitted, my lord.
no. Thank you, sir.
Deeply obliged, my lord.